the end of the day, we'll take it up.
Lordship, item number 65 to 70, Lordship, these are contempt matters. On last date, Lordship, the Honorable Court directed us to produce the list prepared as per termination as well, Lordship. What the authority has informed me that almost ready, Lordship. One division is left, Lordship. I have informed the other side, Lordship, petitioner. Lordship, I will place this on the next date. Lordship.
Okay. Both sides are duly represented. On the prayer of Mr. P. Nayak, Learned Counsel for Respondent number 1.
Yes.
The matter stands adjourned today. Next prayer. The Learned Counsel has submitted that the respondents are in a process of compiling a list in terms of the order of the court, and it prays for some time to complete the process. Some time to the respondents to complete the process. Mr. Matter stands adjourned today, but it goes after vacation then.
I have informed the other side.
Okay.
They also agree.
Okay. List one, give a date after vacation.
Obliged.
Yes.
One matter, item number 47 of civilians 1 matter.
Yes.
Court number 21.
Yes.
This is an urgent matter, my lord. Interim order is here that has to continue. That's why I'm mentioning. Item number 47. Ma'am.
47. Is the other side present? No.
Count by the controversy.
You should mention mention
Obviously, this one.
I don't know.
Item number 47. Court number 21. Interim order is there, my lord. That may continue.
Okay. No, please tell the other side to be here. If I'm extending the order, the other side, Mr. Chauhan,
Yes.
just ask him to be here. I'll pass the orders.
My lord, 7 minutes.
Yes.
My lord, in regard to item number 7 of court number 21, my lord, that was listed, my lord, by orders. Now, since it has been deferred and there is an urgency, I'm making a prayer, my lord, if possibly, if it can be taken as an unlisted matter. It's in the motion column, my lord.
Okay. What is the urgency?
My lord, order appointing receiver and directing distribution of mean profit before evidence has been directed by the learned court bill. The
Okay.
matter is fixed tomorrow.
Okay. We'll take it up.
My lord, will take it.
Understood. Okay.
This very court will take it up, my lord. Obliged.
Yes.
I have to mention a CRP for this thing on Monday.
What is the urgency?
My lord, this is regarding PW, post-examination of PW assessment matter close and fixed for DW.
Okay.
And then
Your Lordship, when I paid for listing of a writ petition on Monday, Your Lordship, actually the matter relates to the non-payment of area increment of an assistant teacher, Your Lordship. The matter was last listed on 22nd of September, Your Lordship. That day, this honorable court directed.
But these are not so urgent matters.
Lordship, this honorable court directed me to file an additional affidavit, Your Lordship. I have already filed. Any day next week, Your Lordship.
Okay, give it to the court master. He'll make some adjustments.
Yes.
We'll do it.
Oblige.
Please, Lordship. Lordship, I beg to mention item number 44. But the matter will be adjourned for today, madam. My senior ICT is not there today. Item number 44. 44.
Okay, you're taking consent of the other side. Okay, with consent of the other side, Mr.
B. Bora.
D. Bora.
B. Bora. B. Bora.
B. Bora, appearing on behalf of the applicant, prays for adjournment. There is allowed. List after ensuing vacation. 44.
Obliged. Okay. Lordship, item number 64 is a bail hearing matter. Lordship, in this matter, Lordship directed to place as the CD. We have received the CD, Lordship, but earlier order was rejected, Lordship, on 17/8/2023. And CD was updated up to 12/8/2023, Lordship. So in this case, Lordship, it is required because after perusal of the CD, earlier CD, Lordship rejected.
Item
Item number 64, Lordship.
The CD is not available.
CD is available, Lordship,
Then,
but that is not updated, Lordship. That is updated up to 12.
no, but still we'll have to take it up. It can't be adjourned like that. If it's a bail matter, we'll consider if the CDs are not upgraded, then we'll see what consequences follow.
Lordship.
Bail is ultimately a fundamental right.
Yes, Lordship.
Infringement of Article 21. We'll have to take it up. We can't be adjourned like that just because police does not upgrade the CD. For that, the court will not sit idle.
Lordship.
Correct.
Lordship.
Otherwise, the courts are under the central government.
Yes.
Or the administratively they can defer the court proceedings by act of a parliament. Correct, huh?
May I please, your lordship?
Yes.
Lordship, I would like to mention one MAC appeal 574 of 2017, which is long.
MAC
pending.
appeal after vacation. No, these are not urgent matters. MAC appeals are not urgent matters. After vacation. You give the mention number, it will be listed after vacation.
May I please, your lordship, I beg to mention item number 34. Lordship, here as per court's order, lordship, agriculture department was supposed to file an additional affidavit. Lordship, I pray for some more time, lordship. I have informed the other side.
Okay. How much time?
Lordship, 2 weeks.
2 weeks, that means goes after vacation. What is the subject matter?
Lordship, they are claiming pay under the 6 pay commission. lordship.
Under 6 pay commission. Okay. With consent of the other side, Mr. V. Chaudhary, standing counsel for the Agriculture Department, raised for adjournment so as to enable him to file additional affidavit. Matter since deferred today, list after ensuing vacation.
May I please, your lordship, I beg to mention these matters for withdrawal as a petitioner has received the statement. Matters will be listed on Monday.
Yes.
Item number 79, to be spoken to.
I've listed these matters, this was forgotten. So,
Start, lordship. I'm sorry, I have misplaced the brief, but I have the notes sheet. I have.
no, that's not, there's only one, there was only one question.
My lord.
Without, yeah, I could answer 194. 190. Driver without the no driver. Huh. Just one, there's only one query.
My lord.
Just let me get my notes. The existence of two provisional gradation lists, is it there on record?
Yes, sir.
Where?
I have filed my additional application.
In the additional affidavit. It was not there in the writ proceedings, it was not there.
The Arya council have to file.
And here there is a reference to a what you call provisional list of 2015. That is also not on record.
Yes, lordship. But in my additional, as per lordship direction, I have been on record the 2 separate gradation lists for the junior engineer, which are regularized to assistant post and regular junior engineer, my lord. That additional affidavit I have filed, my lord, filed on
Is just available 22/11/2022.
Yes, madam. Only thing is the person, the requisition is only the personal post, only that.
No,
is the
that's only this two lists that I did not find in the report.
Yes. Yes, madam. In the report, in the affidavit, it was not annexed, my lord.
Okay. Okay, just a moment. Let the notice available. Oh, okay, there's no other query.
Lordship, I am deeply
So
obliged, my lord.
by next week we'll deal with the orders.
Deeply obliged, my lord.
The matter was listed as the order could not be released on time. So accordingly, the matter is again listed for clarification. Full stop. Clarificatory hearing is concluded. List for delivery orders on Wednesday.
Obliged, my lord.
Of the list, item HP of supplementary list.
Yes.
Lordship almost heard the matter in the last occasion. Only thing that Lordship had indicated whether that clause. That,
22.
That below, I think some wrong clause has been put there in the, but the trial court did not consider that clause while considering the case.
Okay.
Only other things, other clauses are considered and taken note of the various letters which are exhibited to the plaintiff. And the learned trial court also found that the tender, the contract itself is not put to challenge by the terms of the contract letter. So when the terms are not put to challenge, the terms provides that the contract will be terminated.
Okay, I just first hear Mr. Chaudhary.
Lordship.
Then I'll come back to you. There are only two queries to you. Other issues we have almost deliberated on that day. This issue number 3, sorry 4, 3 and 4. The termination of contract of the plaintiff by letter dated so-and-so of general manager is illegal. And whether the order dated so-and-so in respect of contract at the risk of the plaintiff is illegal. So on that, how we have led the evidence.
issue number 4.
Issue number 3 and 4 I'm taking up together. Because first is that whether the termination is illegal, and then comes risk and cost
Yes.
order. It's connected, so I have taken up together.
Paragraph 18 of the evidence for the
Paragraph 18. Yes. Basic transfer contract in survey.
Security deposit হিসাবে রাখে এই কথা পদার্থক দেওয়ার উল্লেখ আছে বাদীর কনফ্লিক্ট টার্মিনেশন করতে বাদীগণে বাদীর সিকিউরিটি ডিপোজিট কৰা বুলি জনাইছে লগতে বাদীয়ে জমা দিয়া বিলসমূহৰ পাব লগা টকাও বন্ধ কৰি বিবাদীগণে কষ্ট ডেমেজ চাৰ্জেছ আদিৰ লগতে বাকী থকা সময়খিনি কাম বাদীৰ খৰচত কৰিব বুলি সিকিউৰিটি মানি বিলৰ বাকী থকা টকা জব্দ কৰি ৰাখিছে লগতে 1 নং বিবাদীয়ে 7/5/2008 তাৰিখৰ টেণ্ডাৰ যোগে বাদীক টাৰ্মিনেট কৰা 25/4/8 তাৰিখৰ পৰা 21/11/8 তাৰিখলৈ বাদীৰ বাকী থকা ঠিকাৰ কাম খানৰ হতুৱাই কৰিবলৈ টেণ্ডাৰ দিছিল যদিও বাদীয়ে জনাত কোনো ঠিকাদাৰ টেণ্ডাৰ নিদিয়াত ডেইলি ভাড়া 3 নম্বৰ বিবাদীয়ে তাক যোগাই বৰ্তমান কৰি আছে বাদীয়ে বিবাদীগণে আপত্তি দাখিল কৰি আহিছিল বিবাদীগণে অন্যায়ভাৱে ডেমেজ মেটেৰিয়েল বাদীৰ পৰা বিচাৰি 17/10/2007 তাৰিখে দিয়া চিঠি প্ৰদৰ্শক 17 হিচাপে দিছিল
No, it's altered. In the original copy, I think it's 17 now. There is a correction here. Who has done it? I don't know. It's 17. We'll just check it out the evidence.
both 17 and 18 corrected.
No, it will be 17.
17.
Yes. Please correct your record.
But here, report inserted to the 3 number there.
No, please correct your record. So that
Yes.
you can make it. Yes.
I don't have the exit.
No, that's okay. Since I'm reading with you, I could. I was following it.
But the deposit inserted to the 3 number divided by 60 copy order of 18/19 11/8 তারিখৰ চিঠি কপি 25/8 এৰিয়া মেনেজাৰক দিয়া 16/2/8 11/2/8 তাৰিখৰ চিঠি কপি 21/2/8 তাৰিখৰ চিঠি কপি প্ৰদৰ্শক 10/21/22/23 হিচাপে দাখিল দিছিল।
Here also there is an alteration. 20, 21, 22, 23.
Yes,
21/22/23.
Correction.
Yes.
টাৰ্মিনেট কৰাৰ পাছত বাকী কাৰ্যকাল 25/8 পৰা 22/11/8 লৈ মুঠ 18,69,000 টকাৰ কাম বাকী থকা বুলি বিবাদীগণে টেণ্ডাৰ দিয়াত এই বাকী থকা কামৰ পৰা বাদীক বিবাদীগণে অন্যায়ভাৱে অবৈধভাৱে চৌকজ দি ট্ৰেন্সপৰ্ট কন্ট্ৰেক্টৰৰ কামৰ পৰা টাৰ্মিনেট কৰে আৰু অন্যায়ভাৱে FCI ৰেলৱে ডিপাৰ্টমেণ্টক দিব লগা ডেমাৰেজ চাৰ্জ বাদীৰ পৰা কথাত বাদিয়ে বিবাদীগণে ডেমাৰেজ চাৰ্জ কথাত অবৈধ আৰু কথাটো অবৈধ আৰু বাদীক টাৰ্মিনেট কৰা 25/4/8 তাৰিখৰ পৰা 25/11/8 তাৰিখলৈ বাদীৰ বাকী থকা ঠিকাৰ ট্ৰান্সপোৰ্ট কন্ট্ৰেক্টৰ কাম বাকী বাদীৰ খৰচত কৰিবলৈ 1-2 নম্বৰ বিবাদীয়ে দিয়া 7/5/8 তাৰিখৰ লেটাৰ SNC বা 1202 আসাম 06 অবৈধ বুলি ঘোষণা কৰিবলৈ প্ৰাৰ্থনা জনোৱা হৈছে। লগতে FCI জেনেৰেল মেনেজাৰৰ বাদীক SNC 1202 আসাম 06 23/11/2006 যোগে দিয়া ট্ৰান্সপোৰ্টেশ্যন কন্ট্ৰেক্টৰ ঠিকা বছৰ 23/11/6 পৰা 23/11/8লৈ মাজতে 25/8 তাৰিখে no workman with like performance contract আইসোলেট কৰা বুলি অন্যায়ভাৱে টাৰ্মিনেট কৰাটো অবৈধ বুলি ঘোষণা কৰিবলৈ বাদী প্ৰাৰ্থনা জনাইছে। লগতে বাদীৰ বাকী থকা 21/12/2007 তাৰিখৰ বিল নম্বৰ 12,000 টকা কটা পেনাল্টি বুলি কাৰণবিহীনভাৱে টোটেল বিল NLP 4/2/8 মুঠ 30,000 টকা ডেমাৰেজ চাৰ্জ 2,000 টকা পেনাল্টি কটা বিল 1/3/8 বাদীৰ বিলৰ পৰা 75,075 টকা ডেমাৰেজ চাৰ্জ আৰু 6,500 টকা পেনাল্টি কটা বাদীৰ বিলৰ 3/4/8 তাৰিখৰ বিলৰ পৰা 11,000 পেনাল্টি আৰু 75,075 টকা ডেমাৰেজ কটাটো অবৈধ বুলি ঘোষণা কৰা প্ৰাৰ্থনা জনোৱা হৈছে। বাদীয়ে মাননীয় আদালতত উল্লেখিত সিকিউৰিটি ডিপোজিট মুঠ 3,59,010 টকা বিলৰ পৰা কাটি ৰখা মুঠ 1,80,150 টকা ডেমাৰেজ চাৰ্জ বিলৰ পৰা কটা পেনাল্টি মুঠ 31,500 টকা যোৱা মাৰ্চ 2007 চনৰ বাদীয়ে দাখিল দিয়া মুঠ বিলৰ টকা 2,22,940 টকা টেক্স কাটি ৰখা আৰু 2008 চনৰ এপ্ৰিলৰ বাদীয়ে দাখিল দিয়া বিলৰ মুঠ 1,61,968 টকা টেক্স কাটি লৈ আৰু কাম ট্ৰাকেৰে 14 দিনৰ কাম কৰোৱা মুঠ 1,000 টকা 14,000 টকা বাদীয়ে মাননীয় আদালতত বিবাদীগণৰ বিপৰীতে পাবলৈ ডিগ্ৰী প্ৰাৰ্থনা জনাইছে। বাদীক বিবাদীয়ে অন্যায়ভাৱে কমকৈ ট্ৰাক যোগাৰ দিয়া যিটো বাদীক দিয়া এপইণ্টমেণ্ট লেটাৰত উল্লেখ নাই। This evidence exhibit 1 is the appointment letter. In the appointment letter, it has been stated that the work assigned to be transported.
Just a moment.
Matter specific.
No, just a moment. Yes.
But in the appointment letter, it has been stated that the amount of work would be amount of work assigned. That means the food grains to be carried out. That should be informed to the plaintiff, and accordingly he will carry out the food grain management. In the appointment letter, it is stated. This is the evidence. বাদীক বিবাদীগণে অন্যায়ভাৱে কাম কৰোৱা কামকে ট্ৰাক যোগাৰ দিয়া যিটো contractor দিয়া appointment লেটাৰত উল্লেখ নাই মাত্ৰ স্পেচিফিক কোৱান্টিটি গুডছ টু বি কেৰিড ট্ৰান্সপোৰ্টেড বুলি উল্লেখ আছে এনেদৰে ইণ্ডিয়ান নিধি বাদীৰ বাবে এমাৰেজ চাৰ্জ বিবাদীগণে ধৰা বুলি অন্যায়ভাৱে বাদীক 25/8 তাৰিখে টাৰ্মিনেট কৰি 25/8 পৰা 22/11 লৈ বাকী থকা কন্ট্ৰেক্টৰ কামৰ পৰা আঁতৰাই ৰখাত বাদীৰ অপূৰণীয় ক্ষতি হোৱাৰ লগতে ঠিকাদাৰ হিচাপে প্ৰায় 18-20 বছৰ FCI কাম কৰা ডেপুটেশ্যনত বিবাদীগণে নষ্ট কৰি বাদীক ডিফল্টিং কন্ট্ৰেক্টৰ অন্যায়ভাৱে কৰা অন্য ঠিকাৰ পৰাও বঞ্চিত কৰাত বাদীয়ে 10 লাখ টকা ইলিগেল টাৰ্মিনেশ্যন অফ কন্ট্ৰেক্ট আৰু ডেপুটেশ্যনৰ বাবে আদালতত ডিগ্ৰী প্ৰাৰ্থনা জনাইছে This is regarding compensation. লগতে 3 লাখ টকা মানসিক অস্থিৰতা অনা আৰু ক্ষতিৰ বাবে দাবী কৰি বিবাদীগণৰ ওপৰত ডিগ্ৰী বিচাৰিছে এই কথা মোৰ জ্ঞান বিশ্বাসৰ ভিত্তিত বাদী বিবাদীগণে যোৱা মাৰ্চ 2008 চনৰ খাদ্যবস্তু পৰিবা ৰোড মুভমেণ্ট পাৰ্মিটৰ চহী কৰি নিদিয়াত বাদীয়ে উক্ত কাম কৰা বিলৰ কিছু বিল মাননীয় আদালতত দাখিল দিছে এই RMPৰ বেকপিঠিত গোডাউন এছিষ্টেণ্ট ৰিপৰ্ট ইনচাৰ্জে চাৰ্টিফাই কৰিব লাগে এনে RMP নোহোৱাকৈ বাদীয়ে দাবী কৰা পিছৰ বিল ডাইৰেক্টলি এৰিয়া মেনেজাৰক দিছিল এই RMP সমূহ বাদীয়ে প্ৰদৰ্শক 26, 27, 28, 29, 30, 31, 32, 33, 34, 35, 36, 38, 39, 40, 41, 42, 43, 44, 45, 46, 47, 48, 49, 50, 51, 52 হিচাপে দাখিল এই কাগজসমূহ গোডাউন ইনচাৰ্জ ৰিপৰ্ট ইনচাৰ্জ আদিয়ে এৰিয়া মেনেজাৰৰ প্ৰৰোচনাতে চহী কৰি নিদিয়ে বুলি বাদীয়ে ভাবিছে যিহেতু বাদীৰ লগত 2002 চনৰ পৰা এৰিয়া মেনেজাৰৰ বিবাদীৰ ওপৰত গোচৰ চলি আছিল এই কথা মোৰ জ্ঞান বিশ্বাস বাদীয়ে ট্ৰাক আৰু মাল নমোৱাৰ সময়ত বিবাদীগণে বাদীক মাল কঢ়িওৱাৰ বাবে ট্ৰাক চিট বনাই বাদী অথবা ট্ৰাক ড্ৰাইভাৰৰ বিবাদীগণে দিব লগা কথা বাদী ষ্ট'ৰেজ এণ্ড কন্ট্ৰেক্ট মেনুৱেলৰ পাৰ্ট 1 FCI চেপ্টাৰ 12 ৰিচিপ্ট অফ ষ্টক ইন ডিপোট 12(1), 12(2) আৰু 12(3) বিতংভাৱে লিখা আছে বিবাদীগণে এই নিয়ম নমনাত ৰিচিপ্ট নিদিয়াত বাদীয়ে বিল দাখিল দিছে বাদীয়ে উল্লেখিত ষ্ট'ৰেজ এণ্ড কন্ট্ৰেক্ট মেনুৱেলৰ চেপ্টাৰ 12 আৰু কপি প্ৰদৰ্শক 51 হিচাপে দাখিল দিছে অন্যহাতে বিবাদীগণে বাদীক কন্ট্ৰেক্টৰ টেণ্ডাৰ ফৰ্মতে এক চৰ্ত সাপ্লাই অফ টাস্কৰ welfare which two warners দিব লগা বুলি চৰ্ত দিয়ে ফলত বাদীক ডিপোজিট ইনচাৰ্জে এখন ট্ৰাক 14 দিনৰ বাবে বিচৰাত ভাড়াত 1000 টকাকৈ প্ৰতিদিনে দিবলৈ বাধ্য হৈছে উক্ত টেণ্ডাৰ বিলাকৰ লগত বিবাদীগণে দিয়া চৰ্তৰ 23 নং দফাৰ ফটোকপি বাদীয়ে প্ৰদৰ্শক 52 হিচাপে দাখিল দিছে বাদীয়ে কাম কৰি থকা পিছত ফৰ্মেল অৰ্ডাৰ নিদি বিবাদীগণে বাদীক 14,000 টকা ঘূৰাই এই কথা বাদীৰ জ্ঞান বিশ্বাস বাদীয়ে ঠিকাৰ কামৰ বাবে শ্ৰী লীলা হাজৰিকা দিবা আকোবাৰী লখিমপুৰৰ পৰা তেওঁৰ AS02 B4419 নম্বৰ ট্ৰাকখন মাহিলী 30,000 টকা ভাড়াত 3/3/2008 তাৰিখৰ পৰা নৱেম্বৰ 2018 মাহলৈকে লৈছিল আৰু আগধন 50,000 টকা লীলা হাজৰিকাক দিছিল। প্ৰদৰ্শক 53 উক্ত চুক্তিপত্ৰ বাদীয়ে ট্ৰাক নম্বৰ AS01L5840 খন মালিক শ্ৰী প্ৰণৱ কুমাৰ নেওগৰ পৰা যোৱা ইংৰাজী তাৰিখে ইংৰাজী 2008 তাৰিখে 6 মাহৰ বাবে মাহিলী 25,000 টকা খৰচ নিগমৰ ঠিকাৰ বাবে ভাড়াত লৈছিল আৰু খাদ্য নিগমৰ ঠিকাৰ বাবে ভাড়াত লৈছিল আৰু গাড়ী মালিকক 50,000 টকা আগধন দিছিল। প্ৰদৰ্শক 54 উক্ত গাড়ী ভাড়াত লোৱা কাগজ অন্য এখন ট্ৰাক শ্ৰীমতী আৰতী ভৰালী বৰবৰী গাঁৱৰ পৰা AS07A3782 নম্বৰ ট্ৰাক 5/1/2008 তাৰিখৰ পৰা কাগজ কৰি ফেব্ৰুৱাৰী 2008 চনৰ পৰা অগ্ৰিম 1,20,000 টকা আগধন দি খাদ্য নিগমৰ কামৰ বাবে ভাড়াত লোৱা হৈছিল। প্ৰদৰ্শক 58 উক্ত ভাড়াত লোৱা কাগজ যোগাড়ীগণে বাদিক খাদ্য নিগমৰ ট্ৰেন্সপোৰ্ট কন্ট্ৰেক্টৰৰ কামৰ পৰা অন্যায়ভাৱে টাৰ্মিনেট কৰাত ঠিকাৰ কাম 22/11/2008 তাৰিখলৈ টকাটো 25/4/2008 তাৰিখে টাৰ্মিনেট কৰাত বাদীৰ অপূৰণীয় ক্ষতি হয় আৰু বাদীয়ে উক্ত ট্ৰাকৰ মালিকসকলক চুক্তিমতে টকা দিব লগা হ'ল। প্ৰায় 7 মাহৰ আগতে বাদীক টাৰ্মিনেট অন্যায়ভাৱে কৰাত বাদীয়ে লীলা হাজৰিকা 3,000 মাহিলী কৰি 2,10,000 টকা আৰু প্ৰণৱ কুমাৰ নেওগক 4 মাহৰ 25,000 টকা লৈ 1,00,000 টকা শ্ৰীমতী আৰতী ভৰালীয়ে আগধন দিয়া প্ৰায় 50,000 টকা টাৰ্মিনেট কৰা দুমাহ সময়ৰ বাবে বাদীয়ে দিব লগা হৈছে। এই সমুদায় টকা বাদীক বিবাদীগণে অন্যায় আৰু অবৈধভাৱে টাৰ্মিনেট কৰাত বাদীয়ে ট্ৰাক মালিকসকলক দিব লগা হৈছে। এই সমুদায় খৰচাত বাদীয়ে গোচৰত বিবাদীগণৰ পৰা ক্ষতিপূৰণ বিচাৰিছে। এই কথা বাদীৰ জ্ঞান বিশ্বাসিত হৈছে। বাদীয়ে গোচৰত উল্লেখ কৰা টাইটেল চুটৰ 9/2002 আপিল গোচৰ নম্বৰ টাইটেল এপিল নম্বৰ 3/2007 মহামান্য জজ আদালতত দিয়া হুকুমৰ স্বাক্ষৰিত নকল প্ৰদৰ্শক 56 হিচাপে দাখিল দিছিল। এই আপিলৰ 8 নং পৃষ্ঠাত মহামান্য জজ আদালতৰ বিবাদীগণৰ FCI লেবাৰ বাদীৰ কামক কৰা হাৰাছমেণ্টৰ বিষয়ে বিতংভাৱে উল্লেখ কৰি FCI নিজৰ লেবাৰ টকা আৰু বাদীয়ে ঠিকাৰ কামত লেবাৰ FCI লেবাৰ কাম নকৰি হাৰাছমেণ্ট কৰা আদি কথা ৰিজনেল মেনেজাৰ FCI ডিষ্ট্ৰিক্ট মেনেজাৰ বৰ্তমান এৰিয়া মেনেজাৰ ইয়াৰ কথা উল্লেখ কৰিছিল। এই কথা বাদীৰ জ্ঞান বিশ্বাস বাদী 3 নম্বৰ বিবাদীয়ে টাইটেল সুট নম্বৰ these are regarding earlier suit. যিহেতু বাদী আদালতত এমআৰএছ চাৰ্জ বাদীৰ পৰা কটোৱা অবৈধ বুলি দাবী কৰিছে আৰু TS 12 হাতত চলি আছে, গতিকে আদালতৰ এই বিষয়ে
This is the paragraph 23 again.
Evidence.
Yes, Vadir Gusau Dulekwa title suit appeal.
বাদিয়ে গোচৰ উল্লেখ কৰা টাইটেল সুট 8/2002 আপিল গোচৰ নম্বৰ টাইটেল এপিল নম্বৰ 3 of 2007
No, not that.
regarding earlier suit.
No, regarding exhibit 57, you were reading
Yes, sir. Paragraph 22
22.
from bottom of it 6 time.
Paragraph 50.
Account of
Six. तो भात लोहा संसो This after 50, after 57, is there any exhibit? No.
Right. Seven is the last one.
Okay. Okay.
So, termination of contract that has been challenged and evidence also has been given by.
I'm asking you for a reason. Because while you were reading, I was comparing it with these exhibits. In marking, there are corrections. So last exhibit is 57.
Yes.
Other exhibits, there's a difference in marking in one number from that exhibit 17 onwards. There's a difference in marking. This is one exhibit. I'm not finding this. That's this is signed by the court, but it is marked. Whether it is exhibit E or something else, I don't know. This doesn't match with the exhibit E of the defendants.
Yes, the defendant side.
But it doesn't match with the exhibit of the defendants. Because in the list of exhibits, which is down below, in the next, you remove this bunch. You just turn over this bunch. No, the entire bunch. Yes, down below is you'll find this defense evidence. No. You're this bunch. First document is list of exhibits.
Yes.
Exhibit E is something else. It says objection. is
Points of objection.
points of objection, but that is not point of objection. I'm unable to correlate.
Yes.
That's why.
Here, it is written kindly refer to the above. I am furnishing here with the desired
RTA reply.
point-wise information. RTA.
No, I don't know. It couldn't be matched. That's why I'm asking you if you're aware of it. Otherwise, not. Then we'll ignore this.
I am not aware.
Okay.
I'm aware of nothing. In fact, I have not gone through any because I'm not aware of the. That's the
No,
problem.
no. Since Mr. Chaudhary was
No, sir.
referring to it, I was just going through it. Otherwise, later on, it becomes very difficult to understand what I've heard.
Absolutely. Absolutely.
Okay. And what is the cross examination
But,
on that?
it's cross part of the plaintiff that I don't.
You don't have it. Okay. Okay.
Only cross part of the defendant side.
Okay. This handwriting will give me nightmares. That's it. এটা আপনারা পঢ়িব পাৰে টান পাই আছো
টান পাই আছো দুই এটা শব্দ ধৰিব
এই দুই এটা মানে এনেকে
নোৱাৰো চব কৰিব পাৰিম নেকি এইটো সব ভিতৰত কৰিব নোৱাৰিলো এই তেনেকে ভালকে কৰিব দিগদাৰ
You're finding it difficult. Even Mr. Das is finding it difficult to read this handwriting. I'll just show it to you because if somebody can assist. Otherwise, again, I'd have to defer this. This is something I can't read.
It's like audio script.
No, I don't know. I find it difficult. Even Mr. Das is finding it difficult, so I'll have to get it typed. No, Mr. Chaudhary, with your slow speed, even you are finding it difficult. I can see you're not very comfortable. I can see from your speed that you're not comfortable. But you can read it with some effort. But that much of time we don't have. So definitely we'll be able to read it, but
Our translator here may.
our translators are busy. They have been assigned some work with by the registry. The Supreme Court is giving much stress on the judgments of the courts to be translated in Assamese and then released, so that the general public can read and understand, to bring transparency in the justice delivery system. So they are engaged there. We are really having tough time. It will take them at least 6 weeks more to complete their assigned work. Because English to Assamese to English we are accustomed, but to translate English into Assamese, it's okay, Mr. Chaudhary. I don't give much effort. We'll try to get it. I'll send it back for the either Assamese writing out for translation. But this is something I can't read. That's it. I'm sorry, we'll have to defer it, Mr. Chaudhary.
Yes.
The submissions of Mr. D. Chaudhary, learned counsel for the appellant, is heard in part. However, the text of cross-examination of PW1 could not be read because of the handwriting. And therefore, the registry has to be directed to either have the vernacular cross-examination either typed in Assamese or translated in English. Stop. In view of the ensuing Durga Puja vacations, court is not inclined to keep the matter part ahead, as it would exceed the prescription of time for keeping a matter part ahead. First, list the matter after ensuing vacation. In the meanwhile, the registry shall do the needful to type out the cross-examination of PW1 either in Assamese or translated into English. I can't keep it parted. Sorry. Mr. P. Roy Leonard, P.K. Roy Leonard, counsel for the respondent, is present. Senior counsel, assisted by Mr. A. Chakravarti, counsel for the respondents, is present.
Supplementary item 81.
Mr. Chaudhary is not there. We can take it out after some time. After some time, serially, after motion. Take it up after motion. That course.
Item 1 of daily list.
Yes.
May I please? Lord, the matter relates to Lord, the compassionate family pension scheme, Lord. And under that scheme, the petitioner being a dependent unmarried daughter of the deceased, Lord.
So we'll have to issue notice here. We'll have to issue notice.
Mine.
This matter. You have complied with the last order of 29.
Yes, my lord, we have, my lord, very unfortunate is that when I, my lord, appeared personally to, my lord, present my representation, that has been declined. Then, my lord, by way of a registered post, I have submitted.
Okay, you have filed an affidavit.
My lord, yes, my lord, I have those records, my lord, and by way of an additional, my lord, I will bring on those records.
Where you have made the statement that it was not accepted.
No, my lord, it has, not in the writ petition, my lord, after this, my lord.
It's okay. Additional affidavit, where you have made the statement.
No, I have not filed that affidavit, my lord.
Then you have to file it.
I have to file it.
Okay, because only after compliance of this, we can
Yes,
issue notice,
yes,
not
yes.
otherwise.
Yes, my lord.
Mr. A.R. Nihar, I'm a counsel for the petitioner. By referring to the order dated 29/2023, has submitted that has paid for some time to file affidavit to bring on record. Steps taken. Just list after answering the question in the motion column. After the question, motion. Because we have great difficulty now in fixing a date after vacation. Because all matters are being deferred after vacation. So we don't know how much big the list would be on the next day. So we are having some difficulty in giving fixed dates.
Item 2.
Yes.
Here that hearing was scheduled on 30th September. That hearing has been conducted. And certain anomalies have been found, and the director of Elimination Department has already written to the BO and the district elimination department for further investigation and verification of the accounts and midday meal details. That instruction I have.
No, then we'll have to issue notice. This is not appropriate.
Lots.
That means till today, charge sheet has not been submitted.
Not submitted, Lordship. Otherwise, this hearing was conducted only by issuing notice to the petitioner only.
No. This, you see, you can go on carrying out any amount of hearing you like.
Lordship.
But is this the manner under disciplinary service appeal rules? No. None appears on call for the petitioner. However, Mr. P. N. Sharma, learned counsel for the school education department, is present and produced a copy of
Communication letter 6
instructions.
issued by the director. Lordship.
To project that an inquiry has been conducted and the matter was sent for further investigation.
In this hearing, Lordship, the petitioner himself was present.
No.
Last.
Hearing, you see, disciplinary, this is not disciplinary.
Lordship.
Where the petitioner also participated. Stop. This inquiry is something which is not, and which is under the Assam services when we get discipline and appeal. Bracket those rules. That is 1964.
Yes.
64. Next paragraph. Therefore, as the petitioner is want to be in continued suspension, issue notice returnable in 4 weeks, requiring the respondents to show us as to why the petitioner should not, the direction should not be issued to set aside the order of suspension. Full stop. Requisite extra copies of the petition be served on the learned standing counsel for the respondents within 2 days. List after 4 weeks. The copy of communication dated 6/10/2023 as produced by the learned standing counsel for the education department is kept as a part of the record. List after 4 weeks.
Daily list item 3.
Wait, please, Your Lordship. So last occasion, my lord, Honorable directed the respondents to produce the, my lord, whether my
Okay.
suspension was reviewed or not. My lord. There's a
Yes.
paragraph.
Yes,
And
my
on the
lord,
other
it
hand,
was
there-
reviewed on 5/7/23.
And what about the appeal filed under 14? What happened to that?
My lord, for that, I don't have that instruction, my lord. Notices to go, my lord.
Hmm.
Only we are only on 2 things, my lord. Whether there was review, that has come, my lord.
my lord,
And he was
No.
Shokos was served upon him, my lord. And he has replied also. On 1/6/23,
No, you look at this order.
inquiry officer is appointed, my lord.
See, third paragraph.
My lord.
Then we issue a notice, otherwise nothing is moving. We issue a notice then.
my contention is that though my learned friend says review was done, till today I am not receiving any review.
You have not received.
Yes, my lord.
Okay,
This is
make
my-
that note.
Because of that, is in camera, my lord, Cameron case is concerned is my lord. Without receiving any suspension order or review order, it cannot be stamped.
I'll make that note. Since it's a motion today,
Number one, second, on the other hand, regarding substantial allowances concerned, then first they have to pay in 50%, but till today not a single penny they have been paid. And suspension order also, there is no any mention, melody one of the permit me matter. The suspension order base 29 man. They have not given any order, whether the
Oh.
first they have to pay 50%, they have to pay 75.
Okay.
But they did not pay anything.
Okay. Mr. N. Bora, counsel for the petitioner, and Mr. Ardhor, learned additional senior government advocate, appearing for respondent numbers 3 and 4. And revenue, you are there, Mr. M. S. Datta, learned standing counsel for revenue department, appearing for respondents 1 and 2. Take 1 and 2 first, 3 and 4 next. Next paragraph. Agreed by the continued suspension of the petitioner since 4/4/2023, non-payment of subsistence allowance, and non-service of the order of review, if any, against suspension, the petitioner has approached this court for setting aside the order of suspension by filing this writ petition under Article 226 of the Constitution of India. Issue notice of motion returnable in, give a fixed date after 4 weeks, so and so, after on so and so. Requisite extra copies of the writ petition be served on the State and Departmental Council in course of the day. Next paragraph. The taking note of the submission made by the Learned Counsel for the petitioner that subsistence allowance has not been disbursed to him. The court is putting the state to notice as to why, for non-payment of subsistence allowance, the concerned officials who are required to disburse the suspension allowance, subsistence allowance, should not be burdened with interest at the rate of 12% per annum to be recovered from their own salary. Full stop. In the event the subsistence allowance is not disbursed prior to the next date of listing, the order to pay interest would follow. Next paragraph, list on so and so. The petitioner shall produce a certified copy of the order before the deputy commissioner. Which place? Page 2. To bring the order to the notice of the said authority. After this, you write fixed list on so and so. Not a deal.
My fear is that they may be produced the record.
They will do it. We are not saying that.
I miss it, obviously.
We are not saying that. They will produce. They know what to do. Mr. Dharis and Mr. Datta are experienced people.
It's not appeal. What he says that the appeal is pending. This is not an appeal. Representation before the deputy commissioner.
Definitely.
Appeal will like higher authority.
Appeal will be for higher authority.
Not
Application praying for revocation of suspension.
He cannot-
Oh, that is not appeal.
That is not appeal.
That is not appeal. That is not appeal.
No, my lord. First, my lord, I am there's due process of law, due procedure, my lord.
No, but appeal under 14 would not be the same authority. It will not be appeal under 14. It may be a representation, not an appeal.
But it is appeal because of that. I am submitted.
No, there is no deemed appeal. Mr. Farag, that is something I don't know. You have to show me that representation to that effect becomes an appeal. There is something I am not aware. Or the next date you show us.
I am submitted to through the circle officer. Due procedure.
No, whatever be, but you have to show us. This is something is unknown to me.
Circle officer forwarded my.
It's okay. On the next date, you show it to us. Show it to us. We are not saying anything in the order. There's something. This is a process which I am not aware. So you will have to show it to us.
Without filing any review application, also, they have to review.
But that's okay. For that we have issued notice. For that we have issued notice.
Item 4.
Sorry, Lordship, item number 1 and 2, Lordship, I will take for respondent number 3, Lordship.
1 and
2, Lordship.
1 and 2.
Yes, Lordship.
Okay, 1 and 2. She's D.D. Burman,
For respondent
additional
number
senior government advocate for respondent numbers 1 and respondent number 3.
Three,
Okay. So Mr. Datta will be only for one in item 3. Okay. Oh, no. Sorry, not in this. 1 and 2. In 1 and 2, she is there. Not in 3. Not in 3. Yes, item 4.
Yes, maybe. The last of the instruction was sought for.
Yes. You got the instructions? No.
Finance department.
You have the instructions? Friday.
The query was at page 24. When the communication to the Treasury Officer.
Yes.
The PPO. It was issued on 2018.
Yes.
I was directed the instruction whether this has been actually been issued by the Treasury. So Friday, that's why.
Okay. Friday next.
Yes.
We'll make it earlier because then we are under pressure for this puja vacation. Wednesday or Thursday, even that will do. Wednesday. Both sides are represented.
11.
No, sorry, the land counsel for the petitioner, standing counsel for the finance department, Mr. B. Gogoi, Ms. D.D. Burman, and the additional senior government advocate for respondent number.
I am for 2 lots, 3 lots.
For respondent number 3, Mr. P.N. Sharma, standing counsel for respondent number 1, 2, and 5 are present. Next, on the prayer made by the standing counsel for the finance department. This is matter on 11:10.
Item 5, entry order may proceed.
Okay, entry order passed today, stands extended till the next date of listing.
Developers.
Yes, 5. Area salary. Area salary, yes.
I have received a telephone instruction also. A fresh proposal has been sought for from the.
Then I'm issuing a notice. I'll record the submission.
So losses and the supplementary budget will be placed losses
Okay.
in the coming budget also.
Mr. A.J. Atia, counsel for the petitioner. Mr. P.N. Goswami, understanding counsel
PN
for
Sharma
the.
losses.
Huh?
PN Sharma.
Oh, P.N. Sharma. What did I say? P.N. Goswami. Oh, no, I'm sorry. Sign of growing old. P.N. Sharma, standing counsel for education department. You're for 1, 2, and 3. And treasury officer,
Treasury officer.
Mr. B. Gogoi, standing counsel for the finance department, and paying for respondent number 4. Next para. Claiming non-payment of area salary against her deceased husband. The present writ petition has been filed under Article 226 of the Constitution of India. Next para. The learned standing counsel for the education department has submitted that as per telephonic instructions received by him pursuant to order dated 25/9/2023, the afresh proposal has been sent to the government.
Has been sought from the district elementary officer.
Huh?
Proposal has already been sent.
Proposal has sent lordship. Because
Proposal has
now
already been
supplement-
sent.
The fresh proposal has to be placed lordship now for supplementary demand lordship budget. So now
Acha,
a fresh
okay,
proposal
okay.
has been sought from the district elementary education officer.
Oh, okay.
Upon receipt of the same, that will be.
Oh, okay. Yeah, submitted that the authorities have sought for a fresh proposal for area salary in respect of the deceased husband of the petitioner from the district elementary education officer. Which place? Nagaon. And as soon as that is received, the same will be placed for supplementary demand in the budget. Full stop. Next paragraph. Be that as it may, issue notice of motion returnable in 4 weeks. Revisit extra copies of the requisition we served on the Learned State and Departmental Council in course of the day. Next paragraph. The pendency of this writ petition shall not be a bar for the respondent authorities to to take appropriate steps for release of the arrear salary of the deceased husband of the petitioner. Full stop. To facilitate the same, the learned counsel for the petitioner shall provide the bank details and particulars to the learned standing counsel for the education department, so that the same can be transmitted to the authorities.
My lord, can we see, 3 proposal has been sent, my lord. Last one.
No, in motion, Mr. Atia, we can't do anything. Even if you do a complete hearing, we can't do anything. Unless I give them a notice and they give them time, nothing is going to happen. You know that I can't dispose of the depression at the motion stage right now.
Fixed date, my lord, after.
You make a mention, we'll take it up, because every matter is now being adjourned after vacation. I don't know how will I manage in the first week of after vacation. Please make a mention, we'll take it up. I'll mention here the response just when in the second paragraph when I've said the counsel for the petitioner has also submitted that as per his instructions, proposal for payment of arrear salary has been sent to the authorities thrice.
Two proposal has been.
Achha, two, twice earlier. Yes, okay. Item 6. Okay. You just first whether the inspector is competent to transfer.
No, madam. Because as per the rules, the competent authority is the appointing authority. Here, the appointing authority, in case of principal, is the director, madam.
The director.
Yes, madam.
So what happens to this? No, that is okay. Somebody may have recommended, but is the if he's not the authority, his transfer can't be implemented.
No, yes, madam. So can we come to the rules, madam? Rule 7.
Which rule?
This,
Education.
Education rule.
That's
This is a new.
New book. That's a new book. I don't know whether I have it or not. It was an kitab.
I have marked it, madam. Rule 7.
Huh?
I have marked it, madam. Rule 7 to 11, madam.
This is with effect from which date?
2022, madam.
No, because this transfer order is of which date?
Transfer order 7th of August 2023.
7th August 2023. Also, this will be followed.
Yes, madam.
Procedure was transfer within the district. Elementary school.
For secondary school, rule 2, madam. 7-2.
7-2.
Yes, madam.
Applicants seeking transfer shall open the transfer portal.
Numerical 2, madam. In the next page, madam.
For secondary level schools.
Yes, madam. Here, madam, the relevant rules is 11, madam. Roman 11.
Transfer order. So I'm then issuing a notice, you respond to it, you say that because it can so happen that the appointing authority has generated transfer order.
Yes, madam.
And the inspector is issuing it.
Here,
It can be possible.
no, madam. In fact, in case of teacher, normal teacher, madam, it is the appointing authority is the inspector of school. But here the case is he is the principal, madam.
No, I get it.
Yes.
What I'm saying is that it can still be possible that the order is generated by the director, and then it is transmitted through the pen of the inspector of schools.
That
So I'm
can-
issuing a notice.
Yes, madam.
But I'll record your submission.
Yes, madam.
But we can't help it. Expressly, this order is without jurisdiction. Mr. K.R. Patgiri, learned counsel for the petitioner, and Mr. N.G. Khatuniar, learned standing counsel for the school education department, and Mr. V. Chaudhary, learned standing counsel for the SSA, and Ms. D.D. Burman, learned additional senior government advocate, appearing for respondent number 4. Next paragraph. The case projected by the petitioner is that his service as principal of the petitioner is petitioner was serving as principal of Kamargaon, K-A-M-A-R-G-A-O-N HS school, and the inspector of schools, which place? Borpeta, had issued online transfer order dated 7/8/2023, transferring the petitioner to Bajali, Bajali HS school, Patshala. However, they said transfer order has not been implemented, and therefore the aggrieved petitioner has approached this court by filing writ petition under Article 226 of the Constitution of India. First of all, it is projected that the petitioner is suffering from various ailments. Next para. Pursuant to the order dated 29/9/2023, the learned standing counsel for the School Education Department has produced a copy of Assam Elementary and Secondary School Teachers within bracket Regulation of Posting and Transfer bracket closed Rules, 2022, and it is submitted that as the petitioner is working in the post of principal, intra-district transfer for persons in the said post is covered by the provision of Rule 7 within bracket numerical 2 within bracket numerical Roman 11 XI bracket closed. Accordingly, it is submitted that the transfer order has to be generated by the appointing authority, who in the present case is the Director of Elementary Education, Secondary Education, Assam. First of all, it is submitted that the order, copy of order which is produced by the petitioner in the writ petition is generated by the Inspector of Schools, Borpeta.
Transfer issued on recommended of the district level committee.
No, it's okay. We are not on that right now. Anybody may recommend, but who is the authority to sign it? That is the question. First, accordingly, seek some more time to obtain instructions as to whether there is any hindrance in implementation of the said transfer order. Next, accordingly, issue notice of motion returnable in 4 weeks. Requisite extra copies of the writ petition be served on the learned state and departmental council in course of the day. Next para. Pendency of the writ petition shall not be a bar for the respondent authorities to give effect to the transfer order dated 7/8/2023. In the event the transfer order is generated by the appointing authority in terms of Rule 7 within bracket 2 within bracket Roman 11 of the aforesaid 2022 rules. Next after 4 weeks. Just before that, you write the petitioner is permitted to serve a certified copy of the order before the which authority?
Director of Secondary Education.
Huh?
Director of Secondary Education.
Before the Director of Secondary Education, Assam, to bring the order to the notice of the said authority. Requisition দিব লাগিব কিতাব
Oblige.
আৰু নহলে এইটো ৰুল প্ৰিন্ট আউট ওলালে নেটত খালি এইটো ৰুল মিষ্টাৰ খাটমিয়াৰ In this book, except for these rules, is there any other change?
No.
No, only this rule is there
Yes, ma'am.
in this book.
Yes, ma'am.
So we can get a downloaded copy.
Yes, yes, ma'am.
Okay. Take this, Mr. Cartonier. Take this book after some time. He'll just note it and then.
Into chapter.
Yes, item 7. Okay, I'm showing this. Your Miss D. Sonwal.
My lord, in this case, the petitioner argue also had a final petition and oral was directed to pay the amount within period of 6 months. My lord, may I?
Where is that?
Case number 24, my lord.
22.
25.
25.
Like,
Then Ms. Sonwal, you have to take a call. There cannot be a repetitive writs for the same cause. So please take advice if you want to file a contempt. Otherwise, in some days' time, your period for contempt is also lost. Take a call because there won't be a repetitive writ petition. For the same order, we can't give repetitive writs. Once there is an order, it's valid for enforcement. So take a call, think over and come at 2 o'clock.
Item 8. This matter relates to the refixation of basic pay and gratuity, Lordship.
Okay, we issue notice. We issue notice. Heard Mr. C. Bhattacharya, counsel for the petitioner. Mr. D. Barat and government advocate appearing for respondent number 3. Then will be first. Miss
1, 4 and 5.
Miss DS Nyok, standing counsel for Irrigation Department, appearing for respondent number 1,
4 and 5.
4 and 5. For 2 is finance. Mr. B. Gogoi, standing counsel for the finance department, respondent number 2. Who is for 3? Mr. Bara, you for 3. Mr. D. Bara, and government advocate appearing for respondent number 3. Then accountant general, your name? A. Lala, standing counsel for respondent number 6. Alleging non-receipt of correctly calculated pension and admissible gratuity, the present writ petition has been filed under Article 226 of the Constitution of India. Issue notice returned within 4 weeks. Requisite extra copies of the writ petition be served on the relevant state and department constituting course of the day. Next, pendency of the writ petition shall not be a bar for the respondent authorities to recalculate the admissible pension and admissible gratuity in respect of the petitioner. First it is same, the petitioner is permitted to serve a certified copy of the order before whom?
Respondent number 6. Respondent number 6.
Respondent number 6, expired list after 4 weeks. 9 is same. 9 is same.
Item 10.
Medical reimbursement. But when there is no scheme, how can you be? How can we issue it to give such a direction?
There is a they have like that is ROP 2017. There they have, my lord, you also will find, my lord. That is, my lord, page 55, my lord. This was brought into force, my lord, in the year 2017, my lord. And there, my lord, they have specifically stated, my lord, under clause, this is 28, my lord. You also will find from the second sentence, my lord. But to extend the medical reimbursement facility to the petitioners of successive companies as recommended by the pay committee, the matter will be considered by the authority under examination of the authority of successive companies for formulating appropriate rules and to issue administrative order by the authority.
Then issue notice.
And only on this, my lord, my conclusion.
Otherwise, they are employees of the erstwhile ACB. Thereafter the ACB was.
Oh, that argument won't be good.
The standing councils for their names have not been reflected. So APGCL and AGCL. There are separate set of standing councils for AGCL and APGCL. Their names have not been reflected
In the cause list.
in the cause list.
But still, I'll issue notice. The names shown, not shown is highly material. Heard Mr. S. Parashar, counsel for the petitioner. As well as Mr. V. Chaudhary, learned standing counsel for the APDCL.
Respondent number 1.
Respondent number 1. He has submitted that there are separate standing counsel for respondent number 2 and 3 respectively, whose names are not reflected in the cause list. Next para. By referring to the which page you showed us?
Page number 1.
5-1.
5-1. Sorry, 5-5. 55 under clause C28.
Okay.
There is a ROP.
Okay. Referring to the relevant clause of the office memorandum dated 12/12/2017 by the APDCL, which refers to medical allowance to employees and pensioners. The petitioners, the petitioner association of the retired employees are claiming medical reimbursement, benefit under the medical reimbursement scheme. By filing this writ petition under Article 226 of the Constitution of India, issue notice, return within 4 weeks. Requisite extra copies of the writ petition will be served on the candidates standing counsel for respondent number 1, as well as to the respective standing counsel for respondent numbers 2 and 3 in course of the day. Next para. The pendency of the writ petition shall not be a bar for the respondent authorities to examine the claim of the petitioner association and extend the benefit of medical reimbursement scheme to the members of the association if they are found entitled to. You have given a list of members here,
No, please,
but then we can't issue any direction.
Association, my lord,
No, you see,
all the
association.
pensioners.
No, you see, association may be. You have heard of this? What is it called? Medusa's head. it crops up. Once you cut off one head, another crops up. So if you have an association, you must have a list of members.
My lord, they have all the pensioners are. my
No,
lord,
no,
members
we
of
don't
the-
know about that.
my lord.
If you have an association, do you have membership of people who are not even whose name do not appear in your register? That can't happen.
No, I provide a list.
Not only provide there, we provide it here also.
My lord.
Because vague orders normally court should not pass.
My lord, I provide a list.
I suddenly remembered Medusa's head. Next one. The petitioners also directed to file an affidavit to bring on record their list of members, and such list should also be furnished to the respondents to facilitate them to examine person-wise entitlement. After this, our list after 4 weeks.
Item 11.
Made with your lordship. Not
Yes.
the petitioner before.
We'll issue a
lordship.
notice at this stage.
My lord.
At this stage, we can only issue a notice.
My only humble submission is, my lord, they have not taken a coercive measure. He has not been released as yet. My lord,
Coercive measures, we don't know what happens in
no,
a.
lordship will kindly see. It's a clear case of malafide, my lord.
No, that we don't know, but you see, you are alleging it.
Yes.
But the issue is that if they are otherwise entitled to take any legal
No, my
steps.
lord, where have we heard a contractual employee being transferred from one place to another? Huh? I'm so sorry.
No, this is
so sorry,
what do you call, this is termination after DP.
Oh, my lord, I thought this is item number 16.
No, this is transfer
I'm so
after
sorry,
DP.
of course, notice. I'm so sorry. my
No, it's okay. It's okay.
Oh, Lord, there's extra matter, item 16. 18. huh?
No, obviously, you will be excited because it has a color.
I'm so sorry.
Okay, and Mr. Ken Chaudhary, Senior Counsel, assisted by Mr. DJ Das, Counsel for the petitioner. Next paragraph. Agreed by the termination of the service of the petitioner after disciplinary proceeding and dismissal of appeal. The present writ petition has been filed under Article 226 of the Constitution of India. Issue notice of motion returned within 4 weeks. Requisite extra copies of the writ petition be served on Mr. R. Dhar, additional senior government advocate who accepts notice on behalf of all the respondents.
1 to 4, my lord.
All the respondents 1 to 4.
5 read,
Full
5
stop.
read.
Okay. The petitioner shall take steps within 2 days for service of notice on respondent number 5 by registered post with AD. Mrs. Chaudhary,
My lord.
This Subhan Chandra Das is by name.
Yes.
Is any malice alleged?
I think
Because inquiry officer is otherwise not.
for the present, my lord, notice to 5 may not be sent. my lord. Let me find out. Possibly is not required, my lord.
No, if there's malice alleged, then it's okay.
No.
But I don't think malice would be
For
alleged
the
in a
present,
degree.
lordship did not issue notice to respondent number 5.
Oh, okay. Just strike out that line. Huh? It expressly appears that no malice is alleged against
Yes.
respondent number 5, and therefore, for the time being, issuance of notice on respondent number 5 is dispensed with.
My lord. Maybe on next date, my lord.
You can
Instruction,
strike it
yes,
out.
we can start.
Next paragraph. List after 4 weeks. Should we call for the records right now?
Let us file everything.
Okay.
Counter.
Okay.
Item 12.
Yes, Mr. Chaudhary, your same matter. That
Item 81.
Oh, so no, this is 12. Okay, item 81 is the okay. Yes.
Letter related to non-payment of some area salary.
Mr. Khan, I have a question for you. You are relying on two certificates given by two different headmasters or principals, whoever they are. You have given two certificates, correct?
My lord.
Saying that you have served the institution. Can you can you tell us in the first certificate what is the period where you have served?
But I served for 1 to 1994 to.
No, look at that certificate and then tell us. Page 24.
Yes, 20.
What is the period?
Here, he had drawn his monthly salary for the period from 1 to 1994 to 31/5/1996, and thereafter his salary was drawn.
Correct. So please stop here. 1 to 94 to 31/5/96. Correct. Now, what is the period in the second certificate at page 27?
Well, look, here something is confused. I have seen.
Ah, yes.
Well, look,
So
here-
now you see, the question is, what is a certificate? No, it's okay. My question is now, what is a certificate?
Well, look, here.
No, don't say it here. I'm just asking you a question. What is a certificate? Certificate is an extract of a record which is available.
Yes, yes.
Now, two principals are giving two different dates. Therefore, there is no record. We disbelieve it. And therefore, we are not issuing a notice. We'll dismiss your writ petition. Or otherwise, we give you liberty to file a record.
Well, look, what I am submitting, Lordship. In the last line, Lordship.
No, you see, let me give an example. It's a horrible example, but still it's an example. For some reason, a lawyer requires a certificate that he is attending the court. So my court master gives him a certificate that yes, from 1990 till this is 2023, he has been attending courts. Correct. Now, is this certificate actually a certificate or it's an opinion of the court master? This court doesn't maintain a role of lawyers who are attending the court. But you're a teacher. You're a grade 5 employee, sorry. So therefore you will have an attendance register.
My lord, that will be, that is there. My lord,
So
I
you
have
get
made
it.
Party respondent of the headmaster.
You get it.
My lord, I have made the party respondent.
No,
of the
no. You
headmaster.
see, just tell me one more thing. Now let us say Ms. Mushari has no dispute with you. She gives a certificate to you that, well, today while coming, Mr. Malla was carrying 1 kg of gold, which was, it fell down in the road. Correct. Now, is that certificate good enough to get you an insurance claim if you have insurance for 1 kg of gold?
We are stand, my lord, maybe the Lordship, as we have made here. the
No,
party was-
he's a headmaster.
My lord.
He will refer to records.
My lord.
Two headmasters refer to the school records and give you different dates.
But in the last line, Lordship.
No,
he
those
served
things I don't
his-
know. Those things I don't know, but that's why it prompted me to ask you a question. What is a certificate according to you? If the certificate,
Should be from the record. Lordship.
because then everybody gives a certificate, the headmaster will give a certificate that he's a citizen of India. They otherwise they say, no, he's a citizen of Australia. Australian government said, I never issued we never got a entry of this person in the country, no record. And the headmaster gives a certificate, no, he's a citizen of Australia. Certificate means business must stop somewhere. You supplement it by an affidavit or we are dismissing your petition. Okay. Heard Mr. M. Malal on the counsel for the petitioner. Next, in this writ, and Ms. S. D. Mushari, standing counsel for the education department, school education department. Next paragraph. In the writ petition, the petitioner has annexed one certificate at page 24, where it is mentioned that he was paid salary from 1 to 1994 to 31/5/1996. And thereafter, his salary was not paid due to lack of retention. Full stop. There is another certificate at page 27 of the rate petition where it is certified that the petitioner had served from 1 to 1994 till 1 to 1996 with pay and thereafter till September 2016 on honorary basis. So therefore, there are two certificates with two different dates, and therefore the court is disinclined to accept the same as a true record of the period when the petitioner had served. The next paragraph. Therefore, the learned counsel to the petitioner prays for an adjournment to bring on record, to bring additional documents on record by way of an affidavit. Accordingly, matter stands adjourned pay list after 2 weeks. No, it goes after vacation. List after ensuing vacation. I'll take a break and come back.
This matter relates to your lordship compassionate appointment. But basically, your lordship, there are three grounds on which it was rejected. And then your lordship, these grounds are not actually correct because of the fact that earlier there was 2 rounds of litigations on this matter. And these matters have been directed by this honorable court to consider on particular grounds. And they have rejected it on those grounds itself. So your lordship will kindly turn to page it starts from 35 and the impugned part is at page 40.
Less than 3 years of service, applicant cannot be accommodated in any division. Application was pending for more than 2 years.
Yes, the first part is that applicant does not possess required qualification for junior assistant. Now your lordship will kindly take up the orders of this honorable court. First order, this honorable court's order. The first case, the order your lordship will find at page.
Is the first application on record?
Application is not here.
It's not here because you see.
But
just. What is it? Yes.
Page 12.
No, I am just trying to show you. This page 12 judgment refers to 4th line, paragraph 2. The petitioner submitted an application on 21/1/2011.
Yes,
correct.
Page 12.
Yes, that's the first line. You come to your synopsis. 4th line, here you say your mother applied on 21/1/2011.
That the petitioner preferred. No, mother has been. It is not it with a correction, my part. Mother of the. It has been corrected here. The mother has been actually removed by
Erased.
Whitener. I don't know whether.
Okay, this is the only thing which caught my attention.
That is, I think, a mistake.
Okay.
Because it has been corrected here, but somehow the
Okay.
mother of the off word has been whitened.
Okay.
Only
Okay.
thing here, like,
Okay. Okay. We accept your statement. Huh.
so what has happened, that order, your lordship, will kindly take up page 14. The last part. Last part, paragraph 13, page 14. The rejection order of the petitioner's case accordingly set aside, even though the period of 2 years has now elapsed. In the attending facts and circumstances, the case of the petitioner is required to be considered in a one-time manner, and as such, the writ of mandamus is issued to the so-and-so district level committee to consider the case of the petitioner in the next meeting of the district level. The district level committee has considered this case, your lordship, as per the direction of this on report, and your lordship will find at the minutes that starts from page 16. The name of the petitioner appears at page 19. There's only one name. Page 19, the first superintendent engineer PWD, Basar Ranjan Dev. Here, your lordship, educational qualification and the post applied for has been shown as LD assistant. And it was grade 3, there are 3 posts, grade 4, there are 1 in Peon, 1 in Khalas. So this they have accepted and send the matter to the SLC. Now, your lordship, what has happened in the SLC, the first minutes, that is at page 25.
Yes.
Page 25 is the minutes of the SLC. Here, your lordship, the petitioner's name is at serial number 97 at page 30. I'm showing this because there are two issues, that's why. Page 30, serial number 97. Now, he has been put in the post of junior assistant grade by the SLEC, though it is not that, it was LDA by the DLC. DLC has actually put his name in LDA. Now they have put it in junior assistant grade 3. So then, here it was given that not within 5% quota and underqualified.
Yeah, LDA is now junior division.
No,
LDA is the same thing, junior assistant
now
now.
it has become junior assistant. It is same. Yeah.
So it's same
Yes.
grade 3.
No, yes. But
Same rank.
Same rank. Not within 5% quota and underqualified. So we came before this on report thereafter, challenging that. Your lordship will find the order of this on report at page 32. The operative part, I'll start from page 33, your lordship. I'll start with paragraph 4. This part has also been dealt with by the on report. Paragraph 4 years. It goes without saying that before the SLC rejects any application on the ground of lack of vacancy, it is incumbent upon the SLC to examine the availability of vacancy in other departments as provided in paragraph 15 of the memorandum. So and so the memorandum has been quoted thereafter. I'm not reading the memorandum. I'll read the next page 34. Further, the petitioner appeals that he applied for the post of LD and not for the junior assistant. He possesses necessary qualification for LD. The earlier rejection of SLC contained in the minutes of the meeting, so and far the petitioner is concerned, is set aside. So that has been set aside. Now, this para 7. In view of the matter, this court is of the opinion that it will be appropriate for the SLC to re-examine the claim of the petitioner. Accordingly, the present petition is disposed of with the direction to the respondent authority to place the matter before the SLC to re-examine the claim of the petitioner in terms of paragraph 15 of poem dated so. So after that, your lordship, this rejection order was passed. There are 3 counts, your lordship. First count is that the applicant does not possess the required educational qualification. Now that part, your lordship, I will show by a judgment of the sound report. Second part, your lordship, applicant's father has less than 3 years of remaining service. This part has been set aside as ultra vires by the sound report in the case of Bhaskar. I'll show that. Then the third part is that the applicant cannot be accommodated in any division. That part I cannot say what it meant because nothing is specific here. And the fourth part is the application was pending for recommendation for more than 2 years. That has already been directed by the honorable court in the very first order that we cannot
take this 2 years. In this case, it has to be considered in with regard to as a one-time measure. You have to consider that that was set aside. So again, they came up with the same. The first order of this honorable court has already dealt of 2 years. The 3 years part, the case of Bhaskar Gogoi, this honorable court has said that that cannot be a ground for non-appointment. And the first part is, your lordship, with regard to the qualification. That is the part where this court in many other judgments have stated that if the person is not qualified for a grade 3 post, he should be accommodated in grade 4 post. There are, I think, 2 judgments in this regard. This is a judgment on in fact, we have also filed a rejoinder affidavit in the main in the writ petition that this judgment of Justice Goswami has already been annexed, where it says that the compassionate appointment, if a petitioner is not qualified for the post of grade 3, then he should be posted. That you will also find in the next page. That is the last penultimate paragraph in the next page, second page. In view of the above submissions of the learned,
Which para?
the first case, your lordship, this is the judgment dated 18/1/2016, passed in 5296. Justice A.K. Goswami, sir. Not the Bhaskar Kumar, second. The second page. Here, your lordship, third paragraph. As is read in Rupam Goala Supra, the case of the petitioner therein for appointment to grade 3 post on compassionate ground was rejected by the district level committee. The petitioner did not fulfill the eligibility criteria for being considered for appointment to grade 3. This court observed that in such circumstances, it is an obligation of the DLC to consider the case of the petitioner for grade 4, for which he is adequately qualified, and accordingly directed the DLC to consider the application filed by the petitioner for appointment to a grade 4 on compassionate ground. On this basis, your lordship, in the next page, the court held that in view of the above submissions, the learned comes for the parties. This consent order is passed directing the district level committee to consider the case of the petitioner in accordance with law for compassionate appointment to a grade 3 post if the petitioner has the requisite, or in alternative to grade 4 post. So if the petitioner is not qualified for grade 3, he should have been considered for grade 4 post. So that is with regard to the first part. And second part, with regard to 3 years, this 3 years part, your lordship, the judgment of this honorable court in the case of once Bhaskar Kumar. Your lordship will find at paragraph 19, 19. Of the judgment, that is at page 37. It is written at the top. Para 19. In view of the above, therefore, this court answers the issue number 1 to the effect that clause 1 of the office memorandum dated so whereby the dependent family members of the government officials who die in harness having less than minimum 3 years of service being not eligible as part of the said memorandum is unconstitutional, being violative of Article 14 and accordingly struck down to that extent. So that has already been struck. So these 2 parts has been dealt with, your lordship. First part is that educational qualification. If he is not qualified for grade 3, he can be accommodated in grade 4. Second is less than 3 years of remaining service. That has been found to be ultra virus by this honorable court, and this still stands because there is no further appeal or any interim or something against this honorable court. Then with regard to the recommendation more than 3 years, that has already been dealt with by this honorable court in the first judgment in the particular writ petition itself, where it says that in this case that should not be considered because that your lordship, the first judgment that page 12 and page 14 it says, even though the period of 2 years has elapsed in the attending facts and circumstances, the case of petitioners is required to be considered as a one-time measure. So on the basis it was considered as a one-time measure by the DLC, but the SLC has again come back with the same point that 2 years have elapsed. It was not there when the first rejection was there. Second rejection they came out. So that also your lordship has been taken care of by these three or the orders. And with regard to your lordship, the application cannot be accommodated in any division in Assam. That part I cannot say because what it meant we are not sure. Because of all these three qualities, he could not be accommodated, or for what? So that part, apart the other three, we have. I can, your lordship, provide the judgments which says that yes, normally it is done. If it is not qualified tree, it will put in grade 4, and vice versa also. There is a case where a person has been put in grade 4. In my case itself, he claimed grade 3 due to his qualification, and he was allowed by this one. Anyway, that apart, the 3 years has been ultra vires, and the 2 years have already been taken care of in this case itself by this one. So these 3 points, your lordship. So there he is entitled to be considered by the, as far as with regard to his, your lordship, if it is qualified, not qualified, it would have been put into the lower grade. In the affidavit that we have filed, rejoinder affidavit, affidavit in reply, your lordship, there also we have annexed the judgment. This judgment is page 5 of that affidavit. This is by Justice Pathar, where again, your lordship, the same issue cropped up with regard to grade 3 and grade 4. The court has directed that as per the requisite qualification, he can be appointed either in grade 3 or that also we have annexed in the affidavit in reply. That affidavit in reply or also the second judgment, that page 5. And in the last paragraph at page 6, the court has said
this against this judgment of Bhaskar Kumar, the state has not gone in appeal.
We have filed an appeal. We appeal 287 is pending.
We file an appeal.
there is no interim order as such.
No, there may not be an interim order, but you see, it's very difficult to. I'm reserving comments. I'll just forward this to you. Paragraph 14. This is Supreme Court.
this is with regard to.
No, you see, I'm not saying anything because for certain reasons. Now you see, what is there is power of judicial review, power to add or subtract. Correct. So you will understand that I'm not elaborating. Number one, and number two, including these two judgments cited here, this is the third judgment on the same point. So it's not only a straight judgment of the Supreme Court of India. This judgment is reiterated twice, and this is the third judgment. The same thing is again reiterated. So therefore, it will be verdict per incurium. That is one point. But still, we have various submissions.
So I have made my submissions. There are two options here. If that being so, and if that part has already been agreed, then your lordship, then I leave it to your lordship, because otherwise, taking into consideration the judgments, which I'm referring as of now, but as the Bhaskar Kumar also, since it is pending, I don't know whether it will go ahead or wait for that. I cannot say that, but it's up to the lordship, because the other points, the Supreme Court judgment will come, your lordship, on a different aspect. But here, the issue only.
The principle of per incurium that can be drawn.
But that will have to be drawn by a larger bench.
No. No. Not required.
By the same bench. A coordinate bench.
Yes, why not?
I have challenged the case on that. In a case, I have challenged that
No, no.
point.
Here you will
In a
find.
division bench here.
Here I will be guided by this insurance case, Pranab, what do you call Pranay Sethi.
Pranay Sethi. Pranay Sethi.
So that is one. There are other decisions. So I have also a comparison on that.
In fact,
And,
my judgment is a full bench judgment by this honorable court, where I challenge that this court does not have the power. It was a division bench.
No, if I differ, you
I
see,
said that
your
lordship
principle
not-
will that principle will apply when I differ from that. But if I ignore a judgment on the basis of the two principles which are exception. Number one, it's a principle of first is per incurium. The second is that doctrine of sub salientio. These are two exceptions to that rule. So if I have a difference with that opinion, then I can't do.
Yes.
So, but if I cite a judgment of the Superior Court and say that the subsequent verdict is per incurium, then I think that liberty is not taken away, because for that there are the Pranay Sethi is in a reference with a different note. It says that when there is a judgment of a condemnation, then the others cannot ignore that. It has to be followed, unless of course it is referred to a larger bench and distinguished. But the principles, these two principles are separate. So I'll take into consideration. I'm not saying because of obvious reasons.
Lordship can, if your lordship can have it today, no problem. Or can have it
No, I'm hearing because this is something I have to take a call. I'm not pronouncing the order right now. That is writ appeal number
287.
287 or 23.
23.
Okay.
Last listed on 17th of August. It was last listed on 17th of August. But there are so many other matters in that bunch of writ petitions. The Honorable Division Bench actually directed the state to file separate writ appeals. So that is actually taking some time. That's why the interim prayer would be considered after all the writ appeals are filed. Each and every individual information.
Okay. What else is your submission?
Subsequently also, subsequent to this judgment of Bhaskar Kumar, many other matters I think have been filed before these are taken up by this honorable court. Maybe your lordship's coordinate benches have followed this.
That
No, definitely once there is a
that was prior to the filing of the writ appeal. In between that particular judgment order and prior to the filing of the writ appeal.
It's okay, just besides the point right now. What is your other submissions here?
Otherwise, your lordship, as per the last order, considering under clause 15, we have considered under this point 3, applicant cannot be accommodated in any division in Assam. So that particular we have complied with as a clause 15.
No,
So
that's not compliance.
that's what
The answer is at page 25.
page 25, page 30.
25.
25, Annex 7, your lordship.
Yes, this is the answer. Look at the parties who are present. They are PWD, WPT and BC, and a personal department. So other departments are not represented. So therefore, obviously, you're not taking decision for other departments. If you are referring to a division, it will only be referable to PWD division. It can't be anything else. So the government has not vested upon itself the authority on to decide on the other departments. Now I checked it, there is no other department. When Mr.
Only PWD and
Manan was
WPT.
arguing, I just glanced to it. It's not there. It's not there.
PWD and WPT are there.
WPC and BT department is there just to ensure that there is adequate representation from the reserved classes.
And the PWD is the only department which is there.
Yes. Finance and personal, they are required. Finance is otherwise because without finance concurrence, it can't be made. Personal, I don't know the reason why.
Personal department.
Appointments are through.
Appointments through the personal.
Oh, okay. Appointing departments is by personal. Routed through personal. Okay.
Only one department.
No, I was not aware of their involvement. So, okay, I'll take a decision then. I'm not saying anything right now because I may also defer it. Join the matter to some other day. You have the pendency of the writ appeal. If I take that view, but if not, I'll dispose it. But you will get the order released on Monday. Whatever order is there, it will be released on Monday. But there is also a likelihood that I may join the matter.
Maybe so. I'll leave it.
Okay. I may still adjourn it. Mr. Y.S. Manan, for the petitioner, D. Bora, Mr. Ardhar, and Mr. Barbujari. You're also there? You're not there? Okay, okay. So, okay.
I requested him to come to the court.
Okay. Oh, 47 court. So he'll come at 2 o'clock.
At 2.
Okay.
Okay.
Yes, item 7.
Item 7 of code 7.
Yes. Oh, acha. This could not be found. Just one. Yeah, if you notice in the matter, pardon me.
Otherwise, even my lord, this the earlier order, my lord, which are under consideration, and that series of matters, my lord, that 14 to 32, my lord is taking after some time. There was a, my lord, government has moved to the finance for 8.26 crore as a granting aid that we are going to give to the corporation.
No,
Half
you
is
see-
also there.
No, you see, what I'm saying is that there was a previous order, and there's still time for filing of contempt.
Content. 1 year is
Successive rate petitions normally it's not envisaged. You got instructions? What? To withdraw, we give you liberty to move the court in contempt jurisdiction. Correct? That would be appropriate because successive rates ultimately, if I issue a notice, even after 2 years, we are passing the same order. There are several Supreme Court judgments, and there is one authored by me also in this court, where successive rates has been deprecated. So that's why, since you have time, I thought to give you an opportunity of taking advice. Ms. D. Sonwal, on counsel for the petitioner, as well as Mr. R. Dhar, standing counsel for
I'm here for 1 and 3, man.
additional senior government advocate appearing for respondent numbers 1, 2, and 3.
No, 1 and 3, man.
1 and 3. And Ms.
G. Swami.
G. Swami,
Correspondent number 4.
standing counsel for respondent number 4. And finance, Mr. Mr. R. Borpujari, standing counsel for respondent number 2. Sir, present. Next, upon instructions, the learned counsel for the petitioner seeks to withdraw this petition and to approach this court under contempt jurisdiction for non-compliance of the order of this court dated 13/5/2023. 22. You know the limitation under 12, it is 1 year. Correct. So you are given an opportunity to give it by the respondents had the opportunity to do it by 6 months.
6 months. So
Therefore, that you'll have to explain. 6 months plus 5 is within 11, but you'll have to come early. Correct. I'm saying so because I'm directing you to withdraw it. So I'm explaining that limitation to you. Take care of that limitation. Otherwise, you lose. According to matter stands closed with liberty as paid for. Yes, item 13. Yes, in this item 13, this is that police case, charge sheet. That charge sheet, that police case and charge sheet is not shown in the net.
Yes.
So therefore, we'll have to give you a direction to produce that document of charge sheet through the police. You'll have to call it from the police. Then we'll have to call them here because we will not postpone the matter only for that. In this scroll, give PP. Huh. Yes, okay. Yes. Give a scroll for PP oblique APP for this code. Any PP or APP should come here. After some time, we will get it because this is not available. The registry could not find it. I've given a scroll. They will come. After some time, because this, we are not getting track of it. No, whoever is, they will take care. They will take care.
Time being item 14 to 32.
There's the last order of 15,
14 to 32.
So ठीक है.
So now what has happened?
Yes, my lord, we have received, the finance department has received, my lord, the proposal for clearance of rupees 8 crore 26 lakh. Now that is under process. I have taken the instruction within next 2 weeks, my lord, it will be clear. They have sent it for, my lord, release of the amount for FOC, ceiling proposal. That is the final stage.
Kindly translate in the terms of what you call time within which they will get the payment. Your submission, please translate it into my language.
Before Puja, they will get it, madam.
The money will go to their account.
Money, madam, it will be sanctioned, madam. It will be.
No, sanction and all. Those are some what you call technical jargon. Because what happens is that you normally issue a what you call your technical release on 30th of March, and then 30th of March at 12 o'clock your treasury will be closed.
Now, here, my lord, this money will be transmitted to the account of the my lord, Department of Private Affairs. They are the administrative department. They will then, my lord, distribute it.
We will refer to the respondent number 5.
Respondent number 5.
And respondent number 5
Okay.
Because
will
we have, my lord, several
accounts.
Yes.
And you are very sure with that money, this the MD will not purchase a car first.
My lord, there is a direction of this honorable court in this regard. There is a direction from this honorable court. Honorable Justice Manaranjan Pathak has passed an order that where this money goes, each account, that has to be again, my lord, once.
Oh, then it's okay. Okay.
Then
Because
that has to be placed.
So this proposal is specific. It will be. It has been earmarked only for the purpose of these week petitioners.
2 weeks. 2 weeks means then we fix this matter on the reopening day.
Absolutely, my lord. Absolutely. Before that, my lord, The money will be
things will happen.
transmitted. Yes, my lord.
Yes. The learned counsel for the petitioners in all the writ petitions are present. And heard. Mr. R. Dhar,
One and four.
additional senior government advocate, appears for respondent numbers.
My lord, here will just indicate that for WPT and BC was.
Okay. Several, okay, right. For WPC and BC department, WPT and BC department, Mr. R. Borpuzeri, then standing counsel, appears for finance department,
My lord.
and Ms. G. Swami, and then counsel appears for respondent number for which department? Assam Plain Tribes Development Corporation Limited. Next paragraph. Referring to the order dated 15/9/2023, the learned standing counsel for the finance department has submitted that as per specific instructions received by him, the financial the appropriate sanction has already been accorded by the finance department,
And my lord, the ceiling proposal. will be
sanctioning a sum of amount, an amount of rupees 826.02 lakh only for the purpose of payment of salary, outstanding salary to the employees of Assam Plain Tribes Development Corporation.
My lord.
Correct.
My lord.
It includes area salaries also,
Yes, salaries.
which
And
includes,
some of the petitioners have already retired, my lord. Their retirement benefits are also
okay,
included here.
which includes area salary as well as retirement benefits of those who have superannuated from service. First off, it is also submitted on a query of the court. It is also submitted that by order dated 7/8/2023 passed by this court, direction has already been issued that the Assam Plain Tribes Development Corporation Limited shall place a list of serving employees, retired employees, deceased employees, along with the amounts so disbursed to them in their respective bank accounts after such sanction of the finance department. So accordingly, it is submitted that there is no scope of money not being spent for the purpose for which it was sanctioned. Next paragraph. Now what we are saying?
My lord, this ceiling proposal, my lord. Ceiling proposal will be cleared, my lord, within next 2 weeks.
Okay, first off, it is the learned standing counsel for the finance department has also submitted that as per instructions received by him, within a period of 2 weeks, the ceiling proposal shall be released. First off, it is submitted that the ceiling proposal is the last stage before disbursement of the money to the Assam Plain Tribes Development Corporation, and the said department and the said corporation, after receipt of money, would make further dispersal of the amounts to the respective writ petitioners. Writ petitioners and other employees of the retired employees, whose name, against whose name this money has been sanctioned.
Here, my lord, this amount of 8 crore pertains to this writ petitioners only.
No, just what I am saying, for the persons for whom it is earmarked.
Yes, my lord, absolutely. Yes, my lord.
Full stop.
And that ceiling proposal, my lord, is the last stage in the finance department. Once it is clear, it will switch over to the department who will turn reimburse it, my lord, to the.
No, that I have already stated.
Yes.
That I have already dictated.
Because, my lord, the final call will have to be taken by the corporation once the money is in their hands.
No, I've added both of them. I have penned on your responsibility and their responsibility also.
Yes.
Both I have touched. Next paragraph. Accordingly, it is submitted jointly by the Learned Standing Council for the Finance Department as well as the Learned Standing Council for the WBC and BT Department, WPT and VC Department, that as well as Learned Council for the Assam Plain Tribes Development Corporation, that on receipt of money, hopefully within 2 weeks, necessary steps will be taken for expeditious disbursal of the money to the persons for whom it is meant.
Absolutely.
First off, as the court would be on vacation, list this matter on opening date is
Opening date is, my lord, 6th.
6th of November. Oh.
Six 11/2023. Which date? The because for the finance department. By which time the Learned Standing Council for the Finance Department, WPT and DC Department, and the Assam Plain Tribes Development Corporation shall regarding disbursal of money due to the accounts of the late petitioners and others for which it is meant. Next, the Learned Council to the respondents shall transmit a downloaded copy of this order to the competent authorities to bring the order to the notice of the said authorities.
Manner. And so obliged.
They get paid, I'll be happy.
Manner, it will be fair. Because that is the last stage.
2016 to 2023.
Whole difficulty here is that the corporation is almost defunct. Now they run on the basis of granting aid. The employees here in.
I think that is the scheme of the government.
Yes.
You don't run any profitable institutions.
Then I may not comment it right now here,
It doesn't appear to be so. Because you see, I find it very difficult to accept that a government institution will not run profitably. All the institutions you are holding, they are what you call monopoly. Then why would it fail? I don't see a reason. Okay, I reserve my comments, as you said.
I am obliged,
Also, item number 54 of similar matter also, this matter also come under that also.
No, my lord.
These are fresh
Fresh matters, my lord. Was these only for this bunch of petitions that money has been earmarked. If now another case is take, my lord, they will not get the money, my lord. That is the.
What is item 54 then? What is it?
Similar matter.
Similar matter, my lord, but my lord, this 8.26 crore, that is already earmarked for my lord specific this writ petitioners and.
This is not meant for this writ petitioner.
Not
No, it may be tied on the same day. We'll make it clear that this money is not meant for them. We'll make it clear. If that is the only reason. 54. Heard Mr. N. A. Lal, counsel for the. A. Nath, I'm sorry. A. Nath, then counsel for the petitioner. Mr. R. Mr. R. Pujari, Mr. Ardhar, and so and so for so and so department submitted that in a bunch of repetitions being WPC 5636 of 2016 and other connected cases. From a submission was made that money is being released for payment of salary and other area dues of the petitioners therein, as well as the retirement dues of ex-employees who are also the rate petitioners. Full stop. The sanctions so issued by the finance department does not relate, does not include the writ petition in the present writ petition, and therefore it is submitted that although the matter may be listed on 6/11/2023, but it may be taken up separately. Otherwise, there would be some confusion in the disbursement of the amount to the other rate petitioners. Next para. Considering the said submissions, it is provided that this rate petition shall be taken up independent of other rate petitions. Next para. Nonetheless, this is the matter on 4/10/2023. Correct?
And so,
Same.
6/10.
6/11.
Code 21, item 7.
Yes, code 21 matter.
Item 7 of code 21.
Just a moment, give me 2 minutes. Where is the plaint?
Come to page number 24. Starts from page 24 up to page 33. The schedule is at page 32.
Just a moment. This application for appointment of receiver was by whom?
By plaintiff's number 1 and 2. Now there are 3 plaintiffs. So plaintiffs number 1 and 2, they have filed this petition, which your lordship will find at page 66.
Okay, so what is wrong in the order?
My lord will come to the Indian order which starts from page 81.
Yes, I've read that.
Yes, and my lord, if I may take your lordship to page 83 for a while.
Yes.
The 4th paragraph from the top, if your lordship kindly takes up, from the pleadings of the parties. From the top 4th. From the pleadings of the parties.
Page 83.
Page 83. There are A, B, C, and then there is a paragraph which starts as from the pleadings of the
No,
parties.
83 first word is argued.
But, your lordship has the impugn order for your lordship.
Just see this. Huh.
Page 84. Page 84.
84. The original owner was the mother of the plaintiff.
My lord, the original owner was the grandfather of the plaintiffs and defendants. He executed a will in favor of his wife and his divorcee daughter, who happened to be the mother of the plaintiffs and the defendants. Eventually, the grandmother and the mother of plaintiffs and defendants, they arrived at a family settlement whereby they relinquished their rights and conferred the rights upon the 2 brothers, I mean the 2 sons, who were the defendants number 1 and 2 in the case. They got their names mutated. They had their names in the records of rights, and they were carrying out the business as per the family settlement manner. There were properties at Delhi where those properties were agreed to be apportioned amongst the sisters, the 3 sisters, one of whom is the pro forma defendant also. Now, eventually, there was an appeal against the order of mutation. There was an objection to the order of mutation, thereafter an appeal, and in the appeal the brothers succeeded. So even they were carrying on with the business over the shops which were on the suit properties. The 2 sisters came and filed a partition suit, whereby they contended that it is an ancestral property and the property is supposed to be divided equally among 5 shares. The defendant number 1 as well as 2, they filed common written statement, joint written statement denying and disputing. Down the line, defendant number 1 changed position. He filed a petition praying for admission decree under order 12 rule 6. That was rejected. Plaintiffs number 1 and 2 filed a petition calling for the records of the mutation as well as rent revenue appeal case. That was allowed. And plaintiffs number 1 and 2, they filed this application under order 40 rule 1, thereby praying for appointment of receiver for collection of the rent and the usufruct of the shops and the godowns which are lying on the suit premises. Now, in this order, my lord, the order now that has been passed to the extent of allowing the petition of appointment of receiver to collect the rent and dividing it equally amongst the 5 sons and daughters. Now, that operative part, my lord, is what, in my respectful submission at this stage, even before the evidence has been led, palpably a wrong order. Because here the observations, if your lordship is taking up page 84, here your lordship will see the observations made by the learned court below, where he has almost arrived at a finding that the property is an ancestral property and it is supposed to be equally divided amongst 5 children. Now, this is before adjudication of the suit in the light of evidence. This is the observation that is being given by the learned court below. And furthermore, the direction is not only for the receiver to collect rent, but also to distribute it equally amongst the 5 allegedly 5 co-sharers. Whereas we are contending that it is not supposed to be partitioned. This property is actually.
Where is your written statement?
Written statement, my lord, will find. The joint written statement at page 34, my lord.
But you have not filed any document, then neither that will is here, not that what you call this, your settlement between the family that was here, nor the sale deed by which you claim that the money was disbursed to plaintiff number 1. That is there.
My lord, my humble contention, my lord, the suit by the plaintiff is at the stage of evidence by the plaintiff, which they have been, my lord, they have been taking adjournments time and again. Now, before the plaintiff establishes their case, the arriving of a conclusion by the learned court below that there is a prima facie case. Now, that in my humble contention, my lord, is at this stage. So far, the appointment of
No, primary case has to be decided. Otherwise, the court can't appoint an arbitrator. Receiver.
My lord, to the extent of appointment of receiver, there is no problem. But your lordship will kindly see the receiver has been directed to collect the rent and distribute it equally amongst the 5 sharers, allegedly the 5 co-sharers. Now, this, my lord, has the impact of giving, my lord, rise to even a proceeding down the line.
CPC2. Temporal tolerance. Okay. Heard. Mr. D. Chakravarti, counsel to the petitioner. Next paragraph. I think you'll have to withdraw it or convert it into an appeal under Order 43 Rule 1 S. CRP would not be maintainable. Order of appointment under Rule 1 is subject to appeal under 43 Rule 1 S. Move the HP if you want, if you don't file a fresh appeal, because in appeal you'll need a certificate. Form will change. Do that correction will permit you to withdraw the wakalatma. We permit you to give a photocopy of the wakalatma and withdraw the wakalatma. That will be returned to you.
Can this honorable court accept a certificate by hand and convert this into an order 43 to 1S, considering the fact that
You can't rectify the, because if it's an appeal, you have to give grounds of appeal. Otherwise, you will be barred under Order 41 Rule 3 to 2 to urge anything beyond the ground of appeal. You'll not be able to. I mean, these things are maybe too technical. You permit you to withdraw it and file it. Agreed by the, just strike that out. Heard so and so. Heard so and so. Agreed by the order of appointment of receiver. The present revision under Article 227 has been filed. So, however, it appears that orders passed under Rule 1 of Order 40 is appealable under the provisions of Order 43, Rule 1 within bracket small s CPC. Post. Next, accordingly, the learned counsel with the petitioner seeks liberty to withdraw this revision and to file an appeal instead. Most of the prayer is allowed. The CRP is dismissed and withdrawn with liberty to the petitioner to approach this court in under appellate jurisdiction. If so advised. Next paragraph. The registry shall also permit the petitioner, the learned counsel for the petitioner, to withdraw the wakalatma by providing a photocopy thereof for the record. I have said if so advised, the reason is that in appeal, the question of jurisdiction will come. What is this jurisdiction of this suit? I don't know. What is it? This jurisdiction in the plaint?
Amount, my lord, is suit value is.
Because if it's a suit for partition, you will give court fees only for your share. You will not give the value of the entire suit length.
My lord, my lord.
It will not exceed 20 lakh, I think.
Because 15 lectures, I'll check it out. My lord, in that case.
Because then the jurisdiction will be before the district judge.
Yes.
That's why I have said if so advised.
Yes. Yes. Obliged.
Also, we just add one more thing. This court or the appropriate court, if so advised.
One more prayer.
Yes, yes.
Since there may be a possibility of approaching the court below, may I pray for the order of this honorable court passed today, if possible, to be uploaded.
I'll try to.
Oblige. I'll not burden this.
I'll try to.
Oblige. Oblige.
You see what happens, Mr. Chakravarti, when I'm in the chamber and passing orders, I'm not remembering the item wise. So what happens is that whatever comes to us, we sign it. We don't keep a track of what orders has to be signed first. So, but she has heard you.
Item 47 of Code 21.
Yes.
Along with the appeal, we filed one IA on 2166/2023. In that IA, my lord, interim injunction was granted. That subject injunction may be.
For willful disobedience. What is the disobedience you have to show us?
Yes, my lord, so we have filed this.
But photograph at page 14, I cannot read anything. I cannot understand anything. It's taken from such a view that I can't understand anything.
Our violation petition ends by page 33.
The which is the order you are saying is violated?
My lord, the order violated, page 23.
23.
20. Order dated 9/8/2023. It starts from page 21, but the order portion from 23. The order.
If I have understood this correctly, there's some confusion. Now, the injunction was refused earlier. Then you came again to this court, and this court said that, well, you are not to be, your peaceful position should not be disturbed. That is the order passed. Correct. Now, in your pleadings, you have said that there was a stop construction order.
Yes.
Correct. And the stop construction order was adhered to for some time, and thereafter construction is restarted.
Yes.
That is your case?
Yes.
But
After
where-
serving, my lord,
No,
after
I
serving-
understand. But the starting of construction, how is it a violation of the order of the court? You are merely said not to disturb your position. Not to disturb the position. It does not say stop construction. High Court does not stop construction. Therefore, if somebody is carrying out construction, well and good, be happy with it.
My lord, they made the preparation to start the construction.
Correct.
We filed objection before the development authority. They passed order Your lordship has seen.
I've seen that. They have stopped construction.
Stop construction.
Now,
So
if they have,
construction was stopped.
correct. Now they have
Construction-
started construction.
Yes.
Now, is
Again,
it a violation of the High Court order?
after serving the High Court's order,
No, no.
They have-
Sometimes you see, when you go to sleep, at least when I go to sleep, I don't sleep on the earth like this. I'm not protecting the earth when I'm sleeping. I just sleep on my bed, take 2.5 feet of space in my bed, and I sleep. Correct. So that is why I'm asking the question, since I don't have a habit in sleeping in the garden with hands open to protect my land. I'm just asking you this question. Starting of construction, is it disturbing your peaceful, what you call, is not disturb your possession?
that's what I am submitting, my lord. Can you
Yes.
see, my lord, initially they made the preparation to start. We filed objection before the authority. They issued the order to stop. So it was stopped.
Correct.
After granting injunction by the Honorable High Court, after serving it, they have restarted. I have used the word, they have again restarted, violating the High Court. Earlier, construction was stopped by the development authority. Now injunction.
I'll tell you why. I'll tell you why. In your plaint, you see the prayer is at page 28 of your revision petition. This appeal. Correct. You have a copy? No.
Copy of the appeal is not with me.
The copy of your plaint is at page 28 of your appeal memo. Now you see the prayer is, I'm just reading it for you if you don't have the brief. It's for cancellation of the sale deed number 247 of 2021 and cancel the order of mutation. Correct. Now, when there's an order of mutation, there's a word written there. In Guwahati, the experience is that they will read khada. That means khoida aru dokhala hutre. So that is the word used in short. So therefore, possession is a requisite requirement for mutation. So that therefore they are in possession is already there. Now your prayer, one of your prayer is to declare your possession over the suit land, for confirmation of your possession over the suit land. Then in this petition, you have never stated that whatever construction they have done should be demolished. Correct. Now in your photographs which you have shown here, in one of the document you have shown a photograph with some sort of incomplete construction. You see, because it is your case that at one point of time there was a stop construction notice. Thereafter they resumed construction. So when I am not in possession, I will not be able to construct. So therefore, possession, this is the second proof that there is somebody else in possession.
In 2018, the title should have been filed.
No, that's okay. But I'm asking you.
And they are the defendant.
No.
From the beginning.
There's besides the point. I'm not working I'm not working straight. I'm working in a fashion which is normally called you will understand jalebi pack. Yes. So this is one of that. Now you see, you see, you're getting my point. You see, number one, I have showed you number one, position by order of mutation. There's a presumption of the correctness of the order, and the authority on the point is section 114, illustration E. All judicial and official acts are duly performed. That is one. Correct. Then second part of position is that it is your own case that they have started construction. Now I am yet to come across, except for landing of the Chandrayaan at moon, I have yet to come across a example of somebody making construction without possession.
In our petition, we have mentioned clearly, my lord, we filed this title suit in 2018.
That's okay.
And they are the defendants.
No, that's okay.
Can you, my lord, just a minute, they are during pendency of the suit, my lord, they tried to, the third party, they entered into the scenario and they approached the owner of the land. And they submitted second time application. First time application was submitted for self-permission with the plaintiff. During pendency of the suit, my lord, the landowner and the third party, they submitted another application for self-permission. DC refused to issue the self-permission. Having failed to obtain the self-permission, they changed the modus operandi. They applied for partition of the land. They, behind our back, they partitioned the land and applying with the new DAG number, patta number, they obtained the self-permission. During pendency of the suit, your lordship knows section 52 of the TP Act. This pendency transfer is hid by section 52. So during pendency of the suit, knowing fully well, they are also defendants in the case, they applied for permission. And behind back of the plaintiff, my lord, they obtained partition, and by using the new DAG number, patta number, they applied before the DC for self-permission, they obtained it, and my lord, very hurriedly, within a very small span of time, they got the land mutated also. They are not in possession, suit is pending. They are not in possession. Our injunction petition is also pending.
No, but then who is constructing this house?
Yes, my lord.
Who is constructing the house?
Defendant.
Correct. So that's what my question was.
One of the defendants.
That's my question was about 1 minute back. That except for this Chandrayaan traveling to moon and putting up their what is spacecraft there.
Your lordship has put the correct question. I understand that if they were not in possession, how mutation?
Yes.
How mutation does that? Mutation on the basis of possession. Definitely, I understand. But my lord, they are not in possession, but how they have obtained the mutation and on what?
No. You see,
How the
the
authority
reason
has issued it.
when I said that I am in civil, I am traveling with jalebi pack. There's a reason for that. Now you see, somebody who is in possession, rightly or wrongly, they may have they are the worst persons. You have said here that he is a criminal. He has been given life imprisonment. His antecedents you have stated somewhere that he is a what do you call? He has been in jail for some time. Those are these. Everything is okay, but you see, by way of an injunction, you can't create a.
Show the conduct of.
No, it's okay. In civil case, how the conduct would be relevant, I don't know. But the fact is that if somebody is in possession, then only they can construct. And by way of an injunction, you can't create a new state of affairs. If he's in possession, by injunction, I can't oust him. Then there would be an order of mandatory injunction to remove him from place. So therefore, his position can't be said to be a violation of the order of the court.
He's not in possession. He's not in possession of the land.
But
What
we
I am
are-
submitting before your lordship.
No, it's okay.
And what is our pleading, my lord? They after getting the registration and after doing the mutation, they are trying to dispose me. They are trying to enter into the land. That's the injunction.
There's a storybook,
My lord.
101 Nights, Arabian Nights. Aladdin, he gets a chirag. He says, build a house. And without possession, the genie comes and builds a house. Yours is not a case of Arabian Nights. Without possession, if somebody is creating, it is your own case that they are constructing.
No, they are constructing means by trespassing money. After serving the High Court injunction order,
Correct. But
if they trespass and start construction.
no, because then
under-
it would be a case that you have misled this court and obtained an order of injunction. Why it should not be vacated? Now that is the question. This is the last point which I am raising. When the construction had come up, the fact that construction had come up during the pendency of the suit is not brought to the notice of the court. You did not amend your plaint. You have not stated that some construction is coming up, and when possession is given to you, in a civil suit, you are required to plead and make a prayer that construction should be demolished. Correct. So once construction is not demolished, then the right of the third party who has created the construction will remain. In a civil suit, that can't be extinguished. You can't be allowed to have profit out of a decree, and therefore, having not said so, you have obtained the order of injunction by way of a fraud upon the court, not stating before the court that there is a construction of a third party in the land. So now, in your application for 2A, why I should not invoke 151 and dismiss your prayer for injunction? Now, this is the question.
No, but we have not played any fraud upon the court for obtaining the injunction. Everything we have.
Where is the
stated in
statement
our
that there was a
pleading,
construction
in
coming
our
up?
pleading. No, there was no construction at all. Construction was stopped, my lord. Very beginning, they made attempts to
Construction was
construct.
stopped at what stage? Some construction, you see, even if one foundation was laid, there is a construction. And there is third party entry into the land.
My lord,
Your prayer, that's what I showed you the prayer first.
yes. My lord.
I've come from your prayer, then I have come from your pleadings, then I have come to your photographs, that this is the construction. Now, you see, you're a very popular figure in this court. Everybody knows you, your smile is very enigmatic. Anybody can be convinced with your smile. Correct. One of the what do you call, you're a counsel having some reputation.
I'm thankful to your lordship, my lord. I appreciate your lordship.
No.
But
Now
fine,
the
my
question
lord,
is,
but my lord-
no, I am on a totally different thing.
Well,
You see, since you are popular, you have many friends. Now just turn around, there are about 20 of your friends sitting behind. You name anyone who will look at this construction photograph and say that this has come up without any time.
No, we have stated in our petition that they made all precautions.
No. You see,
To start.
on the there's nothing on record. I have seen this. That's why I'm asking so many things. Number one, what is the date when the construction came up? What was the position when the construction was stopped?
No,
Nothing is there.
yes, my lord, that order is there.
No.
Stop order is
No,
there.
stop order is there, but at what stage? That is not there. It's
Yes.
not pleaded.
My lord, we have stated in the petition.
You
they
see that?
have prepared to start construction, so it should be stopped.
I
The
get it.
government authority has issued the stop
I get
order.
it, but who has made this construction? You see, this is you see, this is the stage of construction. This is your photograph of construction. Now, can this come up in 5 days, 7 days time? This construction. That's why I said you have so many friends. You can call one of them and show them this photograph. Who can tell you that this construction came overnight?
My lord, I am not telling that.
Because
overnight.
if there is a slab cast, even if the best of cement you use will not give you a steady cast before 21 days.
Lord, our case is very plain. when they made all preparation, to start construction, we informed the authority. Objection was filed. They made the inquiry. Thereafter, they issued the order, stop construction. Thereafter, no construction was made. They were stopped. It was totally stopped. But after serving this injunction order, my lord, they have again restarted.
How is that
your
violation?
lordship will-
That's what my question is. You see, even after 20 minutes, we are same place.
My lord, can
How
you
is
see?
it a violation of the?
My lord, can you see? There are series of judgment. I'll show your lordship.
Show us. Give us a list of
Even
books.
an enforcer cannot be ousted from his possession, settled possession, without following the process of law. That is the well settled principles of law, my lord. Series of judgment I'll show. Now, my lord, in this case, I am submitting before your lordship that there are 12 number of defendants. Defendant number 5 to 7 and 10 to 12. They are the third party. With the plaintiff, with the landlord, there was understanding. They applied for permission. They lost joint izahar the police when there was a dispute with surrounding people. All these things are there. During pendency of that application for sale permission, the third party came up.
No, that I understand. Once you tell me, I'll remember. For some time, I'll remember.
During pendency of this issue, the defendants, third parties, how they can register the sale.
No. That is a question I am not required to answer in this 2A application.
Yes.
It's not a question I am required to answer.
No, our submission is that, my lord, they were not in possession. That's why we prayed for injunction.
But unfortunately, your prayer
Had
you
they
made
been-
was.
my lord, had they been in
Unfortunately, your prayer was not to stop construction.
My lord, had they been-
It was not to disturb your position, and your position is not disturbed. Now, the only question you'll have to answer is why should we not vacate that injunction, which you already have?
No, my lord, your lordship is raising the point. No, my lord, this is not the total area. 2 bigha of land is the shoot property. The area of the shoot property is 2 bigha. And this man, he's attempted to construct only on 15 acres. One small portion in the corner, he attempted. We filed objection. The case is pending, and they are not in possession.
What is the date when you filed your objection?
Illegal way.
What is the date in which you filed your objection?
My lord, the stop order, I am reading, my lord, at page 15.
Page?
Page 15. Stop order by the Development Authority. Page 15 and acceptable. With the order dated 27/7/2022, first para, my lord, has your lordship got it? First para I am reading, my lord. With reference to the above, I am entrusted herewith the copy of complaint letter received from Sri Gurbar Mullah, he is the plaintiff, Gurbar Mullah, against you, which speaks itself for issuing NOC of building construction permission by number so and so, 1st April 2022. These are the, my lord, application on the basis of which this stop order was passed. Thereafter, there was no question of construction. (27/7/2022), and this Honorable High Court's order was served upon him, my lord. After serving this order, my lord, after serving this interim order, page 7, my lord, paragraph 9, page 7, paragraph 9, your lordship will find that the applicants will have to state that the opposite party, after receiving the Honorable High Court's above said injunction order, has again restarted the construction of the building. We have stated my, it was stopped by the development authority. After serving the injunction order, they have again started.
Just a moment. Who's making the construction? The defendant numbers?
Dependent number, my lord, will be dependent number 7, my lord.
That complaint you filed before the Gauripur Development Authority, that is not annexed. Neither it is there in your FAO.
That was not, my lord, in our notice. When we filed the suit,
Okay, so violation is not made out. We'll be dismissing this application. And I'll tell you why. This come to page 14. Page 14, there are some workers there. The nature of construction can't be understood.
Workers are seen, my lord, in
Yes, two workers are there, but what they are doing we can't know, because this photograph is taken from such an angle where the trees and shrubs are there. You can't make out anything. But you see, just behind this man who is bent in the middle, I had to. In the middle, there's a man who is bent.
my lord, 14, at page 14.
Page 14, Annexure 1.
Yes, Annexure 1.
There's one man who is bent. He's doing something we don't know what.
Here, my lord, perhaps no man's picture is there.
There are two people.
Laborer's picture in page 27.
No. Annexure page 14 is there.
14, page 14.
Yes, in the middle. Just stay in the middle.
I'm looking at page 14, my lord.
Yes, then I'll pencil mark in my copy and then send it to you.
Maybe, my lord, it is a bit illegitimate.
You see this.
How the photo has been taken.
I don't know. That's what I'm. You see,
Yes,
your own photograph you can't read.
Photo is difficult to understand, but my lord,
Yes.
regarding these photos.
No, I'll tell you.
We have stated that
No, I will show you something.
preparation was taken.
No,
Yes,
it's
sir.
okay. It's okay. I'll show you something.
My lord, one more
I'm not
thing.
saying just for anything.
These photographs has not been served on us.
Not served. Okay.
So my
Look
lord,
at
you
this.
can sue both the
I given
petitions and
I given a pencil mark.
just my lord will check out the notice.
No, it's okay. Once you say that, I don't need to check out. Correct. Now you see, there's a reason for that. In that mark which I have given you, just behind that you will see a wall. Correct.
My lord,
No, I don't know about anything. I'm just reading that photograph.
my lord, I have submitted before your lordship very small area.
No.
Only
You
15
see, I'm not on that.
No,
Let me complete, then you will understand what my thing is.
My lord,
I don't
nearby-
speak straight.
My lord, nearby area, adjacent
No,
plot, there
I-
are buildings.
You see, that's why
There are buildings.
once you say, you see, the date is very relevant. 14/3/22 is the date of photograph.
Yes. 14.
14, yes, 14/3/22, somebody is there in your land. Correct. And in the plaint, nowhere I've just read your entire plaint, the written statement. Nobody has made any statement with regard to the possession of what you call some construction being started. It's not there.
No, my lord, possession means.
No. You see that those stories won't help you, because I'm a better storyteller.
No, my lord, possession does not mean that one person will enter for a.
No, I understand, but Mr. Malay, I can tell
Possession
you.
will be taken and he will be told that he has the possession.
No, that I don't. It's your photograph. It's not somebody else's photograph. You are annexing it on a violation application.
My lord.
So that's what I'm telling you. Stories, don't worry. I can. I'm a good storyteller, so don't worry about stories. But the second thing is that 14/3/22, you say that somebody are in your land. You give a complaint to the authorities in 22, and the stop construction order comes. Correct. The complaint is made before the authorities on 29/6/22, and then this stop construction order comes. So therefore, in 22, somebody else was there in your land. Therefore, this violation application has no merit. I'll pass orders in chambers. I will be dismissing it.
No, I paid for response to agent 9.
And these copies are not served on him. This is additional ground to dismiss it.
It's totally different thing they're giving.
No,
It's okay.
Totally different.
No, my lord, When
You can
we have
check out
filed this
yourself.
petition, when we have filed this petition, my lord, they were not, they did not enter appearance. How can?
He's
we
government.
start?
He's government.
For the state, my lord.
He's government. He's already
It's totally
omnipresent.
different thing, my lord.
Government is omnipresent. They are everywhere.
And that is why saying what my lord is saying may be correct, my lord, because they were trying to hide it from the state, because we'll find out through the police.
There's one more ground. If it is not,
My lord will record that.
we'll take your copy and make it a part of the record.
And my lord will record the petition also, the appeal also. My lord may see the appeal also at the same time. Both
Okay.
the-
My lord, sir,
They are totally different things.
by mistake perhaps.
No, no. These
This
are
is
not
something very
appreciated.
serious because we will obviously find out through the police. That is why they are hiding it from us. This is something very serious. And they are accusing our officers also. Because they are unhappy with the, because we allowed the sale deal. Our officers are involved there. This is a very serious thing there. Their jobs may be gone, my lord. You can't take away someone's job like that.
This violation has been filed by lord.
We are
against-
simple people, my lord.
Against
In the bottom of the hierarchy. Very small
Okay, I'll
officers.
consider.
Violation is not against the government.
No, no. Whatever be, but he's making an allegation that is not served. Is not. If he doesn't have a copy which is there in the court, it gives us an additional ground to dismiss it.
My lord,
That is absolutely not appreciated.
my lord, actually.
I'll compare it.
Yeah,
I'll
no,
have
no,
I had
our
compared.
Understanding, my lord, that this violation has been filed against the defendant number 7, not against the government.
No, that's okay. But once a copy is served and it's not in accordance with our rules, this is not. I'll get it compared. Don't worry. I'll pass orders in the chambers.
Obvious. My lord, the petition we can be sent back to the government office, my lord. I can retain it for now.
Let me compare it first. Before I jump into conclusions, I
And my
must
lord will say
do
one
my
more
duty.
thing. First time we refused permission for sale. Then after about a year, they again applied, the party. Then only we granted. It is not that it happened in one day. The first time we refused.
No, we are not hearing the suit. It is only a violation application.
Yes.
So we are not entering to the merit at this moment.
And the police was also involved in certain stages. So they obviously know that through the police will
No,
find
we
out.
don't know. We are not hearing those things right now.
My lord,
Yeah.
your lordship will be pleased to see page 6 only one.
What is there? What is there?
Page 6. So we have stated, my lord, in paragraph 4, that the landowners and the third parties changed their modus operandi and they got the land partition and again applied for sale permission on 13/11/2020. Second time they, after partition, they applied for sale permission on 13/11/2020. Sale permission was issued on 1st February 2021. Kindly see the measure began. 1st February 2021, sale permission was issued. Sale deed was registered on 8th February. 1st February, permission issued. 8th February, sale deed was registered. Applied for mutation on 9th February, very next day, 9th February. And land was mutated on 10th February, next day.
It's okay. That you can challenge. You see, we have for revenue side, we have the deputy commissioner, we have the board of revenue.
No, just to show their conduct, conduct of the third parties, not the government. We are not against the government. We are against the third party. So
No, we don't know, Mr. Mala. You see, I have to save some time. I can't go on carrying out with it because I am right now concentrating only on the violation, not on the other aspects.
My lord, I leave it to you.
Not on the other aspects. For that we don't have time. If we have to hear it, we list it after 3 years for hearing. Then we'll hear it.
My lord, this is regarding violation.
No, that's okay. But if you want to make submission, if you are ready to make submission, I am ready to hear it. But after 3 years,
My lord, that injunction.
we'll fix a date in 26 for hearing. If you want to hear, argue more.
No, my lord, I am submitting violation petition. I am leaving to your
No,
lordship.
then that's okay. The end of the matter.
That-
Every good thing must come at an end. The best of the movies have end. After 3 years, it will be the end. We have to come out.
I'm leaving to your lordship.
No movie hall permitted me to stay beyond 1 hour, that 3-hour ticket.
My lord.
Correct. Best of the movies and best of the halls, best of my contacts. No, Mr. We'll see that. Whatever is there, we'll consider. But every good thing must come to an end. Yes, next.
Item 36 with 37.
Yes, Your Lordship. Item number 37 and in all probability has become infructuous because in item number 37 we have challenged the transfer order. So I've been telephonically instructed by my client that it was transferred to Hailakandi. Now again he has been transferred back to Dibrugarh.
Okay.
So that, Your
So
Lordship,
this
item number 37.
37.
Yes, Your Lordship.
Okay. Mr. R. Sinha, the counsel for the petitioner, come upon instructions, has submitted that as per telephonic instructions received by him, the petitioner who was earlier transferred to Hailakandi has again been transferred, and therefore this matter has become infructuous. So accordingly, in view of the said submission, this matter stands closed, having been rendered infructuous. Mr. KK, you are there. Okay.
In 37.
7. We are 13-7 now.
37.
We are just recording your presence. Who are there?
Mr. D. Gugoi will appear for 1 to 5.
D. Gugoi for respond number 1.
2, 5. 1 to 5.
1, 2. Achha, 1 TO2 5. And Mr. D. Bora, Learned Government Advocate, appearing for respond number 6. Correct? Are present. Okay. Now this 36.
In 36, you are challenging allegation that has been made against us, Your Lordship. So that is regards to that, they have to file an application, affidavit.
No, my lord, that I can produce judgments, my lord. This, he's agreed by show cause.
No, let him complete. Let him complete his submission. Huh?
Your Lordship, what happened when you've been transferred, we filed an appeal for the government. So that appeal was rejected on the ground that this transfer was punitive in order. There's some incident happened in one of the hotel, and we have been found there was some negligence of duties on our part. So against that order, we have filed in this application challenging that show cause notice. Because our entire case is that I was in no way responsible for the incident that happened in that particular hotel. So as regards to that, he has to file a affidavit. So what is the stand? Because if that remains, that will be a stigma upon me, Your Lordship. Because that notice was issued in pursuance to disciplinary proceeding. So what is the outcome of that? They have not stated anything like that.
No, what is the order in appeal? What appeal was there?
It was different, my lord. These are two contextually two different. Once, in one matter, he was transferred. He didn't join. Something was drawn up. A show cause was
No,
issued.
his facts
No,
are not
no.
correct.
There's
His facts are not
some
correct.
reference to some appeal. Let Mr. Sinha submit, because I have to have a clarity. If I hear both sides together, I'll not understand the facts.
Your Lordship, I was transferred from Tinsukia to Hailakandi within a span of 1 year, 3 months. So I made a representation to consider my transfer order. So that representation was disposed of, and accordingly, I was issued with a show cause notice. The show cause notice, if Your Lordship kindly say,
No, I'm just asking you, what is the appeal referred to?
the appeal was against the transfer order, Your Lordship, which was rejected. I was
Okay.
transferred, I filed a representation.
Okay.
That was rejected. Then I filed the appeal before the principal secretary. So during the pendency of that appeal, I was issued with a show cause notice. That transfer was punitive in nature in view of the fact that an incident happened in the hotel for which I was held responsible. I am not a field officer. So I have challenged that show cause notice, Your Lordship.
Where is it? Show cause notice?
The show cause notice at page 66, Your Lordship. Annexure 8. May I read, Your Lordship?
In this writ petition, you challenge that order of transfer. Oh, sorry, show cause notice. Issuance giving you a written show cause notice why disciplinary proceeding should not be drawn up against you.
Yes, sir.
But this challenge would not be maintainable. It's only a not only a show cause. No, it is, don't disturb the proceedings. It's something I dislike. Twice or thrice after that, I have a. You know, yesterday what happened? Cloudburst. No, you don't read. In Sikkim, there was a cloudburst.
My lord,
Yeah, I may also have an anger burst.
I apologize, my lord. I did not want to.
There can be an anger burst here also.
No, no, I don't.
I don't normally misbehave.
My lord.
I don't normally misbehave, but if you are pushing me in a corner, continuously disturbing the proceeding. I have said many times in this courtroom. No, Mr. Gogoi, please understand. In this courtroom, I always give an example. There are only 2 cities in the country where people ride by time. If in Bombay or in Calcutta, you have to catch a 4:21 bus or a 4:21 train, you have to be there at 4:21. Correct? There are 2 cities where time are maintained. So you're not catching a city bus.
My lord.
That I have to catch a city bus at 4:21, therefore I have to rush.
No, my lord.
No. If you don't have to catch a city bus or a public train, then please sit down. Allow others to complete.
Yes.
Yes. Or otherwise, you can always get a declaration from the court. Since I already have an experience of some civil side, you can give a declaration that you are the only knowledgeable person. You can speak for everybody. You can speak for the petitioner. You can speak for the respondent. Please don't do it. I told you that it will be anger burst at any point of time. I'm too touchy on these things. When I stop you from doing it and you stand up for the 3rd time, it not only shows your disrespect to the court, it also shows disrespect to your brothers and sisters on the bar. If you don't have that etiquette, don't be in practice. Don't make me speak those things which I dislike. I like my life to be smiling and completing the day end of the day. And the end of the day, I want me to go home without any dead body carrying in my body. I don't carry anything on my head when I go back home. I leave everything here and go home. So if I carry a dismania in the courtroom, there's something I always carry. I don't want that. I want to be a happy man, smile and go away. I start my day with a smile, want to end the day with a smile. Don't push me to a corner where I speak something which you regret. And even I will regret having spoken that. It's not my nature to have an outburst. I always give an example of Honorable Justice B.N. Singh Nilam. On one day in the courtroom, something pissed him off. He got angry. And then he walked away from the courtroom. Next item was mine. I was shocked that what would happen in my matter. And then I asked the court master that what would happen to my case. My case is the next one. He went inside, came back and said that sir has some cooling time. So after some time, in the second half, we'll sit. So about half an hour, I took rest. Because he said that other case would be disturbed if I carry the anger. So he went inside. Twice in my court proceedings, I have rised. If I was disturbed, I stood up and went out because this incident of Honorable Justice B.N. Singh Nilam it is there in my mind that I should not misbehave in the courtroom. And if I lose my temper, it's better to go inside and take a rest instead of disturbing the cases of others. So please bear in mind.
Well, I
Don't
get it.
repeat.
Well,
Don't repeat. Don't what you call interrupt when the other side is making a submission.
Well,
He may be Mr. Sinha, may be the worst of the speakers. He may not be speaking unnecessary things, but he's addressing me.
well,
If I am ready to hear this unnecessary blickerings, let me do it.
well.
Yes. Yes. But this is only a show cause notice issued to you, prior show cause notice. Why initiation should not made? There is not a subject matter challenge.
Your Lordship, Annexure 6, page 61.
Page 61.
Yes, Your Lordship. When I submitted the representation against the transfer order, this order was passed, wherein the third paragraph they have said, as per record, it has been observed that Sri John Fukan was.
No, whatever be the reason,
Yes, Your
we are not on that. Reason may be anything. You may have a very good reason, but a prior show cause notice, why disciplinary should not be initiated against you? Can that be a subject matter of challenge? Whatever be the background, he's only telling you why you should not be proceeded against.
Your Lordship, this was put to challenge in that view of the time because the transfer order which was given effect to, that was punitive in nature. And because of that, it was put to challenge for subsequent, Your Lordship.
This would not be maintainable. If you get a show cause, you contest it. But why you should not be given a show cause notice? How that can be under challenge?
The reason was that there was an incident in the hotel, and I was no way responsible for that because I was not in the field, Your Lordship. In view of that, it was challenging.
No, I agree. There may be 100 of good reasons. I'm not saying that you don't have a good reason. But can a prior notice, why show cause notice cannot be issued against you? Can that be a matter of challenge?
It was challenged at that moment, but I think at this moment, Your Lordship is correct. At that moment, I had to challenge it because this show cause notice.
Now, subsequently, you have transferred.
Yes.
Everything was.
Yes.
Close your matter then. Yes, you have to say anything.
And I was just pointing out, since this matter is only the stage of show cause, Honorable Court might
This is not a show cause, it's a prior show cause. It's not a show cause.
This is reply, my lord.
Hmm.
That's all. I was submitting that.
Heard Mr. R. Sinha, counsel for the petitioner, and Mr. D.D. Gogoi, Leonard
D. Gogoi.
D. Gogoi, signing counsel for the respondents. Next para. I don't say anything. It's because of the subsequent transfer I close it. Otherwise, I'll have to make a remark that may not be upon instructions from the learned counsel for the petitioner submitted that as subsequent transfer has already been given effect to, in all probability this writ petition is infructuous, and accordingly it is liberty to withdraw this writ petition. Please allow him to withdraw this writ petition with liberty to approach again if so advised. So accordingly, this writ petition is closed with liberty as straightforward.
That transfer order has been given effect on 3rd of October 2023.
Subsequent transfer order has been given effect to on 3/10/2023. Okay.
Deeply obliged.
Item 81.
Yes, Mr. Chaudhary, or item 81. No, it's okay.
Yes.
Yes. A transfer to a casual employee is not envisaged. Unless you can show that it can be transferred. He's a casual employee.
He being an employee, my lord, service of the government, my lord, in this case, the situation there, the casual employee is actually owing an amount of rupees 23,000 per month, and this is going to be till the date of his superannuation. It's like any other employment, except that pensionary benefits are not there. Since he being in the service of the government,
I'm transferring the incident of service.
For a casual employee, shows the law.
The reason you given actually.
No, you see, you are giving him a post of LDA. You give him the salary of that LDA.
Since he being a casual employee, regular pay scale is actually not active.
No, but how can you give? You see, that means you don't want to make recruitment in the state. We'll have to take it that the government doesn't want to fill up the post in a regular manner, and therefore they are employing casual employees somewhere and transferring to him to do the substantive work in a vacant post. Tomorrow you will appoint a casual employee as a chief secretary if he has the qualification. Casual employee, because he will then toe to your what you call dictates. Casual employee, giving him a permanent post. I have known master roll worker and this and that, but appointing him, transferring him as an LDA. I can understand a casual employee being transferred from the one place to another for his convenience. The state government transferring this is usually to show some law, some rule in your state, which permits you to transfer an employee to a substantive post. From casualing employee, you are transferring him as LDA to one place. Give him that salary attached to that or that post. But that means you are not filling up that post. And there's a Supreme Court judgment that not filling up a post again is not a appreciated act. What is that judgment, Mr.?
That means you need regular hand, yet you are not filling up.
No, there's a Supreme Court judgment. It says that
I just forgot the citation.
not is sometime of 90s, 1994, 95, sometime like that.
In the context of that hire and firing policy.
Hire and fire policy, yes.
It implies that means there is a necessity of a regular hand.
Yes.
Yet you are managing it through casual hands.
Casual hands.
That means you are paying because you have got larger bargaining power. And my lord, the employees they do not have.
That word is also used.
Yes, bargaining power.
Bargaining power is used in that judgment.
That concept started with my lord that Ghaznamer Ganguly's case. Then the
Okay,
LIC
I
case,
won't know that.
It started with Ghaznamer Ganguly.
Those days I was only reading one book. It is now that I am learning this service laws. Otherwise, I was what you call insect of this book. This, whatever be your good reasons, this transfer has to be stayed. Or you have a liberty, you can appoint him on the same post, you pass a fresh order, but give him that salary attached to that post, regular salary to that post. He may be a casual, but give him a regular salary of that post. If he's a casual, you're not giving him house rent, free house. You're not giving him anything, what you call, anything else which is attached to that post.
As far as casual employees are getting, what they're getting is the fixed wages of rupees 15,900 with DNS allowances, and
It comes to 23,000.
which will undergo revision whenever pay scale changes based on enhancement of DA and recommendation of pay commission along with medical allowances of rupees 600.
My lord, they are all appointed against some personal post. They are retired, the post will be abolished.
Yes.
No, what you call, casual employee for the purpose of convenience is given attached to a post.
Yes.
Correct. But will it come within the definition of what you call this temporary employee, temporary post and permanent post? They will be covered by the definition.
No, man. Temporary has again a different connotation.
Give that service rules, fundamental rule. Fundamental rule. FRS.
FR9, my lord. 927.
Do number. Manual peaceful, standing book. Do number fundamental rules.
923 or 27.
Something like that,
Yes.
huh?
FR9. There are three kinds of post, my lord: permanent post, temporary post, and supernumerary post.
Supernumerary is that is
Yes, all defined in FR9. Then there is a tenure post also in there. 4 kinds.
yes, permanent post means a post carrying a definite rate of. Yes, you are right. 922. FR30 is temporary post.
Yes.
Meaning of a post carrying definite rate of pay. So you see the requirement of this is that it must be substantive and can be held in officiating capacity. If you can show that a casual employee can be given to work at that post, then we'll ask.
But this particular person, he was already working as LDA in Contempt.
No, you may have given now. You see, since you have transferred down, it is being questioned. Otherwise, he is happy with that.
Yes.
Now, once you have transferred, then the question arises whether you can put a casual employee to a substantive post without appointing him to that post. Appointing means a regular appointment. I may be excused for the words. I may miss something. The words I miss sometimes. But without a substantive appointment, regular appointment, can you do it? And can the court permit it? So we'll stay with this transfer. You come out with any other order. You can come up with any other order. If you want to appoint him at that place, you do it substantively, you do it.
Short date may be given.
Monday?
Tuesday.
No, but I'm staying it. Even after that, you want to short it, I'll give it. Okay. But Mr. Kian Chaudhary and his senior counsel, assisted by Mr. D.J. Das, counsel for the petitioner, and Mr. N. Devnath, learned standing counsel for the PNRD department, as well as Mr. D. Boral, learned government advocate, appearing for respondent number 2. He's for 1 and 3. Huh? Next paragraph. The petitioner, who is otherwise a casual employee, is aggrieved by the impugned order of transfer dated 29/9/2023 from which place?
From Karimganj Jila Parishad to Biswanath.
From Karimganj Jila Parishad to Biswanath Jila Parishad. And according to the present writ petition has been filed under Article 226 of the Constitution of India. Next paragraph, the learned senior counsel for the petitioner submitted that the petitioner is getting a fixed pay of rupees
my lord, 23,000. Total emolument is 23,000 and odd.
No, that rate will be something else. It will should be 15,000 something.
15,900 plus dearness.
15,900 plus dearness allowance, and the total emoluments come to rupees 23,000.
Exact figure, 1 second. I'm giving that figure, my lord.
23 so. With no house rent, with no entitlement to house rent allowance.
23,680.
680. With no house rent allowance and
Nor I will be entitled to TADA for transfer.
okay, and now he will be entitled to an ETA and DA for transfer. First of all, he is referred to other grounds taken for the challenge to the transfer. Next paragraph. If you notice a motion returnable on Wednesday, 11/10/2023, requisite extra copies of the writ petition we served on the learned state and departmental counsel in course of the day. You get it copies, give him today. Today, in course of the day. Next paragraph. Having noted that the petitioner, being a casual employee, is transferred to Biswanath Zilla Parishad to a post of LDA, which is a substantive post. And on consideration that the petitioner is not being offered the salary attached to the said post, and considering that the petitioner is not entitled to transfer DA and TA or house accommodation, the court is inclined to stay the operation of the impugned order. Which page?
Yes, 23.
The order number is on page 23. Number
So far as
so
it relates to the petitioner.
insofar as it relates to the petitioner, namely Sri Kalyan De Purkayastha. List on 11/10/2023. The same name should I take up?
As I was speaking this morning, madam, there's also an order, madam,
Okay. Next, at this stage, the Lawrence Standing Council for the PNRD, the department has submitted that he has received instructions in form of order of release bearing memo number so and so, dated 6/10/2023. Full stop. In view of the interim order passed today, they said, consequently, they said, order under memo number so and so, dated 6/10/2023, shall also remain suspended and shall not be given effect to till the next date of listing. List on so and so. Just I'll add there. No, not it. It's something which can be done.
Time being, item 13.
Item 13, adjourned for time being. Yes. Yes, you are there. Okay, this I checked through my own what do you call internet. There is no information coming out of this. It's not being tracked. So I've also sent it to our IT team. From these numbers, they have not been able to retrieve either the data is not uploaded in the in the intraoperable criminal justice system. So it's not available. So there's a reference in the last order. If you can kindly come to this, okay, showing the writ petition.
26.
Yes, page 26. You find there's a reference to particular case number 189 of 1999. And this next paragraph shows There are charge sheet number 121 of 2014 was submitted. Now we require this document itself. Because if if the police station even has sent the charge sheet to the court, they will have a copy.
Yes, Lord.
It has to be maintained because then only they give you instructions, or they will have that entry made in their register, movement register. We need that. Correct. Because the petitioner says that he has not been able to have access to this. He has applied for certificate copy, is not getting it. And now because of the pendency of the criminal case, his salary is, he's retired and is not getting his arrear salary and pension. Correct. So by when you can provide us these details?
What's 18th of October by 18th? Next week.
And there's one more thing which you will kindly note. Give a copy of the petition.
Yes, Lord.
You have it? Okay.
Sir, I have
Now
taken-
you come to this page 20. Office of Director Land Records.
Yes, Lord.
This is Rupnagar. So if something has happened resulting in the lodging of an FIR against him, the authorities will not come to Pandyar and lodge a police case. So I think either the reference to Pandyar police station would be wrong. Very unlikely. There's something happening in the jurisdiction of Rupnagar. Will come to Pandyar.
Not so in the FIR it is stated as Contempt police station case number, but in the synopsis, but I have found. Contempt police station.
I
case
am going with the last order. I have not
Lord,
read
sir.
the synopsis.
Okay.
Synopsis says Paltamjar. His election in Paltamjar. So can you check that also?
Yes, Lord.
Because this is missed, it missed my notice. Paltamjar PS. So if it is Paltamjar, we were searching for in fact Paltamjar. That's why it is not showing. Paltamjar we have not checked. We checked Paltamjar because in the order page 26 Paltamjar is referred to. Paltamjar. So I have reading it wrongly. We checked Paltamjar. No, but my section, I sent the file to my section, the IT section. They will, I think, read it and say Paltamjar, but they have also not been able to show that. But check it out. This is what I am just pointing it out. It may not be. Mr. D. Bhuyan, on counsel for the petitioner. Mr. For government who will be there, Mr. D. Bora, government advocate appearing for respondent number 2. Mr. R. Bhattacharya, standing counsel for respondent number. No, Mr. Bora, you will not be for 2. Revenue 1, finance. Revenue is 1, Mr. Bhattacharya. Acha, you'll be there. Mr. S. Datta for respondent number 1 and 2. 1 and 3, okay. 1 and 3. 2 is finance. Acha, okay. Mr. Bhattacharya for 2 and 5. Director of pension will be you. Mr. Bora will be for 4. And accountant general, she was here, that girl, What is her name? I forget her name. Okay, Mr. R.K. Taludar, Council for Response number 6. Next paragraph. At the request of the court, Mr. K. Bushel and APP has also appeared to assist the court. Next paragraph. By the case of the petitioner is that while he was working as assistant machine operator, assistant machine operator in the office of the Director of Land Records and Surveys from Assam, he was placed under suspension pending not full stop. He was also arrested in connection with Paltamjar PS case number 189 of 1999. Full stop. By an order dated 14/6/2006, the petitioner was reinstated in service. And the issue of regularization of his period of suspension was kept in abeyance till the disposal of the criminal case. Full stop. The petitioner superannuated from service on 31/10/2020 and is getting only provisional pension. Full stop. I'm not getting it right now. That's Saxena, SC Saxena. Where is the impugn order of transfer?
Page 21.
31.
21.
21.
Effective page 22. Serial number 9.
So here that no reason has been assigned. If you had good grounds, you would have assigned a reason. That's not there. We file a response. In the meantime, we extend the status quo. Mr. J. Karita, counsel for the petitioner. Mr. P. Handik, I'm sorry, I forget. Mr. P. Handik, standing counsel for the PNR department.
1 to 4.
Place for is granted. 2 weeks further time. 2 weeks he will be able to file it.
3 weeks time. After.
So then we go beyond this revision. Given granted time till the reopening after vacation to file affidavit in opposition in the matter. So interim order passed release stands extended till the next date of listing. List after 4 weeks. Okay. You made a prayer for upgrading. Which is that item? Because I have to go early. I may not have time to take up other matters because the meeting scheduled at 4:30. Any prayer you have to make, please tell the court master.
That is 72, it will be better. 70.
Yes.
Yes. This was being along with so many other cases. Now finally she pays 12 months.
Oh, this education and finance, you are there?
Education.
Education and finance.
IA number 2217.
2217.
Yes.
It shows the causes where your name is not there.
Yes, that is in lawsuit that I have annexed. And the whole list of those dates. When the case was dismissed.
So it shows the page, shows the relevant page.
Yes, I'm sure. Yes, 18.
Oh, very good. No, just Mr. Mahmood, I have to formally issue a notice because this is there is a note here about the delay, so I have to put them to notice. We'll give a short date, but we'll restore it after that time. No, but a formal notice has to be given when the issue of limitation comes. That means a right has been created in their favor. I have to give them a notice, then to do it. But where is that page for this?
Yes, 18.
80? 18.
Yeah, you can do that.
No, you just show that the cause list.
And 18 to 30.
Show me the relevant page where your name is not there.
Name is not there, well, it's the case, that case is not there also, what my name is there. in the old order, it was written that on 2/2, we were absent. But on that day, police is there, because in some cases, our names are not at all there, in some cases, even the case is not there. Here one, that is the test 24, case 24.
No, just a moment.
Case 24 and 20. Where case now, cases there, but
No, you see, 31. Page 31, this matter is listed.
at one cases listed, our names are not shown.
Okay.
22,
We'll give you a notice. If you have no objection, then we can allow it today. But if you have an objection, we'll have to fix a short date. No, because see page 31. Give him a copy, otherwise he can't say anything. You see, this. No, I'll show it to you. You come to page 27. (27) is the bench of code 18. No, not this is not 27. This is 27. Yes, code 18, right? Now come to this page of 31. Serial number 48.
31 is not, 30 is there. 30, page number 31 is not there. 7058. I 22173.
I am at miss case 63. I'm having miss case 63. You see from here. First is that page of 27, code 18. Correct. Come to page 31, serial number 48.
Name of the petitioner is not shown.
No, counsel name is not there. Name of the petitioner is there, Salimuddin, but counsel of the petitioner is not there. And in the connected repetition, you see WPC 2031, the name is shown as Mr. BK Das. BK Das is not the counsel, he says. 2031.
This is not listed along with this one.
7058. Where is 7058? Oh no, 7058 is something else. Okay, 7058 is the rate petition. His name is not shown.
also says
It's okay. Just it will This is the repetition. No, to Mr. Sharma. Mr. Shadi and Mr. Sharma, this. So he's the lawyer on record. His name is not there. So we should notice or we can allow it. Applicant is not, name is not there. Okay. Mr. M.B. Mahmood, learned counsel for the applicant. Also heard Mr. P. Bora, learned standing counsel for the education department, school education department, and Mr. Shalia, learned standing counsel for the finance department. Next para. What is 592? What is miscase 592? Okay. It appears that the proceedings of WPC 7058 of 2015 was dismissed for default by order dated 11/11/2021. Full stop. The applicants then moved this court with by filing IS Civil 592 of 2022 for restoration of the said writ petition. Full stop. The said IA Civil 592 of 2022 was dismissed for non-prosecution by order dated 19/9/2022. In the said order, it is reflected that the case was previously listed on 23/3/2022, 27/6/2022, and 3/08/2022. The same was not prosecuted. Full stop. In this interlocutory application, the applicant has annexed the copy of writ petition. Sorry, a copy of the cause list of the concerned courts when the matters were listed. When IS Civil 592 of 2022 was listed on 23/3/2022, 27/6/2022, and 38/2022. Full stop. It appears that on 23/3/2022, the case was listed for court hall number 9 at serial number, serial number 51. But in the cause list, the name of the learned counsel for the applicants was not reflected. Full stop. On 27/6/2022, the said matter was listed before court hall number 4 as item number 10. However, the name of the learned counsel is not reflected in the cause list. Full stop. On 38/2022, the matter was listed before court hall number 13 as item number 7. And again, the name of the learned counsel for the applicant was not reflected in the cause list. Full stop. Ultimately, when the matter was listed on Ultimately, the matter was listed on 19/9/2022 before court hall number 18 as item number 48. Again, the name of the learned counsel for the applicant was not reflected in the cause list. Full stop. Therefore, next paragraph, therefore, the learned counsel for the applicant has been able to demonstrate that on the 4 dates when the matter was previously listed, the name of the learned counsel was not reflected in the cause list. Full stop. Next paragraph. In view above, although Mr. P. Bharat and standing also for the Education Department and Mr. A. Chalia, learned standing also for the Finance Department, have objected to this to the prayer made in this interlocutory application, but the court finds that there are good and sufficient cause for the applicant not to be represented when IA Civil 592 of 2022 were listed. First of all, accordingly, this interlocutory application stands allowed by restoring the proceedings of IA Civil 592 of 2022 on file. Full stop. We listed this matter after vacation because these few days will not be able to take up.
On that day, even the case was also not number
Okay.
71. Dismissal order.
In this IA 592, right? In view of the order passed today in MC 63 of 2023, this interlocutory application is restored to file. So list after ensuing vacation. This is over. Now, Hafizur Rahman. No, just a moment. Let me get the files first. Hafizur Rahman. IA Civil 325. 76. Hey, Hafizur Rahman. Hafizur.
WPC 6786.
Number
325. No, just a moment. This was order to 9. Where is the order of the court dismissing our application?
Page 112.
A order to issue.
WPC 67861.
Mine. No, just you're not getting it in sequence. Where is the order of 911? No, 211. First is 211. Where is that order?
But it is reflected in the order 911. 911, 21.
Where is 911 order? Page? No, this application only has 13, 14 pages.
That is 3 to 5, IL65.
No, 3 to 5 is already disposed of. 3 to 5 is disposed of.
Case is not registered. Case of the WPC is not registered. It is said that 211 we are not present. 911 we are not present. Then 1111 case was dismissed. But in all these 3 days, the case was not.
No, your 325 has been restored. In 325, application for restoration of WPC that was restored. 6786 has been restored. I don't know. Check out this representation is restored. 3 to 5. No, don't read the entire order. We don't have time. I have a meeting. What is the last order? Last operative paragraph. What does it say? No, last operative part. What does it say?
Operative part. In view of the aforesaid determination, the ratio shall equally be applicable when an application for registration of petition is filed, which was dismissed for non-prosecution. Therefore,
So that is restored. So once that is restored, then why we need 11? This is
this case regarding limitation. Dismiss case. This I am regarding limitation in other one is for restoration.
The case is
The cost type
filed under limitation method, but not under limitation. Section 5. Observation was there that limitation was allowed, but clearly restriction is restored, that is not here.
okay. Limitation is allowed.
Yes.
Okay. So 211, you say that is not there. 911, where is the order? $111 or what? No. Come to this application now. I am in MC11. You have not realized that.
Yes, MC11.
Yes.
MC11, that is for registration.
So where is this? Where is this 911 order?
911 is not here. The next in there. Condemnation.
It's in the condemnation application. Okay, where is that?
In condemnation petition, that may be seen as triple one.
Where will triple one come? 325 has only limited pages. It has
This matter may come some other day.
no. Let it come some other day because I am not getting it. There is no triple one here. The triple one is not here. Due to positive time, matter could not be taken up today. List after ensuing vacation. First is allowed because you could show it. But the second case, you are saying to 111 pages is not there. You just check up with the record. Because if you and I we are holding different briefs, it will be difficult. Yes, please come.
Yeah, sorry, I'm actually making a statement with respect to item number 81, in which the order is in clause. May I be provided a copy of the order? If you have it sent to me.
Okay, we'll try to get it, but you'll get some. It will take some time. By the time I sign it, it will be about an hour or so. The orders will be transcribed. You will right now then go back and transcribe by 6 o'clock.
Das.